Yeah, please, my lord. My lord, I'm praying for listing of the writ petition.
Listing all prayers, please give it to the courtmaster. All prayer for listing, give it to the courtmaster.
Obliged, my lord. Please, your lordship.
Listing
I'd like to
done,
mention
or list.
listing for one writ petition. On Wednesday, lordship.
You have heard him. You have heard him.
Lordship.
You have heard the courtmaster.
Listing tabdil.
On 8th, lordship.
Dates I am not giving.
April, lordship. Lordship, I'd like to mention item number 29. Lordship, the matter may be adjourned for it.
All sides are represented on the prayer made by land counsel for the petitioner.
Lordship, I'm for the respondent number 6, lordship.
6, okay. You have taken consent? No, then don't make a prayer. Without consent, no adjournment. Renew the prayer when the matter is called. No ex parte adjournment.
A daily list item 1 for motion.
I agree with your lordship. I agree with you. My lord.
My lord. I beg your pardon, my lord. Instructions, my lord. My lord, instructions I don't have, but my lord, I was just want to place one recent judgment of the Supreme Court that I think my lord will take care of this matter, because my lord will note one thing, that the petitioner's husband died in 2005. 2005, my lord. Now, my lord, that I have, this is a judgment, my lord, that I have flagged, my lord, that 7.5. My lord, this is a recent judgment by Honorable Supreme Court, where guidelines has been laid regarding this, my lord, delay. May I read that 7.5, my lord? Debabrata Tiwari. Debabrata Tiwari versus West Bengal. West Bengal, my lord. My lord, I'm reading 7.5. Considering the second question referred to above in the first instance regarding whether application for compassionate appointment could be considered
My lord, I have not gone through the judgment, but my lord, I have also other suggestion, my lord. So far, my lord, my case is concerned, my lord. I think I should say I'm very unlucky, because my lord, in spite of direction of this court, my lord, it is a very clear direction, my lord. My case has not been considered, my lord. That order of this court has not been taken care of, my lord. My humble respectful submission, my lord. Kindly see, my lord, if I may allow to refer, my lord, our judgment, my lord, kindly for a moment, page 126 and 27, my lord. Paragraph 6, 7, and 8, my lord. Just to refresh, my lord, lordship memory, my lord. Para 6, my lord. And 7, my lord. Page 126 and 27, my lord. Now, my lord, it is clear, my lord, direction to the respondent authority that, see, this was what happened in the year 2008-9. That he could not be considered on the part of the DLC. So now this court, honorable court, clearly says, giving a direction, making a time frame that you should not by any means, my lord, consider in the next DLC meeting, and you should not reject the case on any technical ground, including, my lord, late submission of application. That was what this court specifically directed, my lord. Now, my lord, kindly come to page, my lord, the copy of recommendation, my lord, page 138 and 39, my lord. Page 138, my lord. It's that, my lord. If I may allow, my lord, last paragraph, my lord, page 38, Roman 3, my lord. The TLC recommends or reject proposal on the basis of information furnished by the respective department. And if any complication arises, says the concerned department will be answerable to the court. Further, recommendations are made on the basis of available vacancy in the concerned department as reported by the departmental representative on the day of the meeting. My lord, that line may be perhaps important, my lord. Now, my lord, kindly next page, my lord. Serial number 3, my lord. That is my name, my lord. Petitioner. In pursuance to the Honorable High Court order dated so and so in connection with WBC number so and so, the proposal of Srimati Meena Kumari Singh has been recommended for grade 4 post. My lord, considering the vacancy, my lord, status available of the vacancy, my lord, and taking care of the Honorable this court direction, my lord, my name has been recommended, my lord, in grade 4. Now, what happened, my lord? Let's see, my lord, the SLC, my lord, page 150, my lord. 150, my lord. Lordship, got it? The decision was held, my lord, on 2/3/2023, my lord, after a lapse of more than 1 year, despite, my lord, court 150, my lord. Yes, my lord. See, my lord, I just want to indicate one thing, my lord, here. Yeah, my lord, the reason, before that, my lord, the reason why I could not be recommended, my lord, here, they say that could not be recommended as per the OM due to late submission of application. My lord, here, two aspects, my lord. Could not be recommended on the basis of OM, which OM it is referring, they are referring to is not, it's not clear. Secondly, my lord, they have, my lord, rejected my case only on late submission, my lord. Despite, my lord, court has given already direction, my lord, that you should not be on that, you should not reject on that ground. That was what court has directed. My lord, left side, my lord, see, my name appears Meena TV Singh, my lord, wife of Sir Yung Singh, my lord, that is important, my lord. Sir Yung Singh, my lord, here, my lord, this is not my husband. It is my father name, my lord. So, my lord, this itself, my lord, this rejection itself appear that, my lord, they even does not, my lord, with my humble respect for submission, they does not know who, against which post I am applying for, why I am applying for, who is my husband, even they does not know, my lord. And even in the impugned decision itself does not say anything, my lord, that they have duly considered the DLC recommendation, or they have duly taken into consideration the direction passed by this honorable court, my lord. Nothing reflected, my lord. And my lord, very important things is, my lord, my husband, my lord, expired in way back 2005. And that at that point of time, my lord, there was no any time frame regarding submission of application, as your lordship is aware. Anytime they can apply, my lord. It was only, my lord, time frame was framed in the year 2009, and subsequently, my lord, that was extended beyond 1 year, up to 1 year by the Ferguson Nisa judgment. Lordship is well aware. So, my lord, no question at all arose, my lord, that my application had spent time force on, there was a less submission of application on part of the authority, my lord. And my case has not been considered, my lord, not because of any lapses or negligence on part of the applicant, my lord, petitioner, my lord. And it appears, my lord, from the impugned rejection that, my lord, they have not duly taken care of the direction passed by this honorable court, my lord. So, my lord, only my humble submission, my lord, let them, my lord, bless once more, my lord, let me try my luck once more, my lord. I've been, my lord, all along, my lord, pursuing my lord, grievance, my lord. Simply, my lord, I am, my lord, it has today, 2024, does not mean that my necessity is over, my lord. I could not in a position even to uphold the dignity of my lord, my family members, my lord. It's very, my lord, in a very hardship condition, my lord, I'm running my livelihood, my lord. So, my lord, once again, my lord, let them consider, my lord, that will be my humble, respectful submission, my lord. Otherwise,
My lord, compulsion appointment, my lord. My lord, we have done away with, from 2017, there is no compulsion appointment. Now, that is, we have stopped, 2017. Those persons we have died after July 2017, no compulsion appointment, they will be getting, my lord, compassionate family pension. No, that is, my lord, prior to 2017 July, who have passed away, they will, that will cover them. No, my lord.
my lord, so far my knowledge is concerned, my lord, page 121, my lord. 120-21, Annexure 7B, I have enclosed, my lord. There was a memorandum, my lord, on or 31st March 2017, my lord. Clause 5.11, my lord. Page 121. Clause 5.11, my lord.
My lord is disposing of this matter, my lord. My lord, let me place my case, my lord. Then, my lord, please, now you sit. My lord, I'm just quoting that 7.5, my lord, where that has been dealt with. The judgment, my lord. I have flagged it, my lord. That's 7.5, my lord. Considering the second question referred to above in the first instance regarding whether application for compensation appointment could be considered after a delay of several years, we are of the view that in a case where for a reason prolonged delay, either on the part of the applicant in claiming the compassionate appointment or the authorities, my lord. Here, my lord, the Supreme Court has clarified even the authorities. Authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of death of the government employee. In such circumstances, courts or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other source. Granting compassionate appointment in such a case, as noted by the court in Hakim Singh, would amount to treating a claim for compassionate appointment as though it were a matter of inheritance based on a line of succession which is contrary to the Constitution. Since compassionate appointment is not a vested right and the same is relative to a financial condition and hardship faced by the deponent of the deceased government employee on the consequences of his death, a claim for compassionate appointment may not be entertained after a lapse of considerable period of time since the death of the government employee. So, my lord, here is a case, 2005, we are in 2024, 19 years has passed from in between, my lord. In between, my lord, she has received, the petitioner has received family pension, that is, she has been receiving, my lord. That part is there. So, my lord, that immediacy, that is lost. That part is diluted. So, my lord, because of this reason only, my lord, further, my lord, direction from this court, my lord, may not, my lord, be passed, my lord. That is our humble prayer, my lord.
NC Santosh.
NC Santosh.
NC Santosh.
That was the subsequent judgment, my lord. My lord, after some NC Santos judgment, my lord, subsequent my lord judgment, my lord, para 8 and 9. Para 8 and 9, my lord. 9 will be relevant, my lord. My lord.
Right. You're getting sound? Yeah. Para 7.4 and 7.5, the case of Tiwari and others is super put it below. Next, follow this code by the previous order dated 7/1/2022, passed in WBC 7363 of 2019, and issued a direction for consideration of the candidature of the petitioner. With the direction that the candidature should not be rejected on the ground that the application has spent force or on any other technical ground. But in view of the law laid down by the Supreme Court of India in the case of Devarvata Tiwari and others within the Supra, the said order of this court would not be implementable. Therefore, having noted that the husband of the petitioner died in harness on 13/11/2005, and 18.5 years have gone by. The in light of directions contained in paragraph 7.5 of the case of Devarvata Tiwari and others within the Supra, the candidature of the petitioner cannot be ordered to be reconsidered. Accordingly,
My lord,
repression fails in the same is dismissed.
my lord, every facts may be different, my lord. Here, my lord, what, my lord,
It's
Yeah,
okay. After
my lord,
I dictated the order, I'm not
See, my
reconsidering
lord,
it.
see, my lord, what I'm trying to impress is, my lord,
I'm not
whatever,
sorry.
whatever the action, my lord, on the part of the respondent, my lord, that was not any fault on my part, my lord. It
No,
was,
sorry,
they
we are
have
not
been,
saying, we are
they
not
have
saying on your
keep
fault.
pending petition years
We are not
together, my
saying-
lord, and
we are
now
not-
they are
we are not-
saying, my lord, you
Mr. Murray,
are delay,
I've dictated the order.
my lord.
I've dictated the order.
At least my one chance, my lord.
No.
Otherwise, my lord, see, my lord, I had placed a
Item
class
2,
addition, my lord.
item 2.
Motion item 2.
Oblige, my lord.
What is the date of the order?
I will allow to withdraw this petition
Okay.
due to some
Your
mistake.
name,
Liberty to file a press release.
your name,
Adopted.
Aditya. Okay. Upon instructions, Mrs. Aditya and counsel for the petitioner seek to withdraw this petition and to approach again. Here is allowed, matter is dismissed. On withdrawal with liberty is grateful.
Item 3.
Mr. Bora, Mr. Chakravarti. I'll have to take, I'll be taking time to come back to service law. So please be equipped in all the matters. Correct. It'll take me 1 or 2 days to realign myself with this. I'm issuing a notice that it non-appearance call for the petitioner. However, next one, the removal of the petitioner on the ground of unauthorized absence from duty by order dated 15/11/2020, passed by the commandant dash disciplinary authority, 22nd Assam Police within bracket IR bracket battalion in sealed by filing this petition filed under Article 226 of the Constitution of India. Next one. Mr. D. Boral and CEC accept notice on behalf of all the respondents.
Not CGC, government advocate.
Huh?
Government advocate.
No, this is, oh, okay, the government accept notice on behalf of all the respondents. Extra copies of the petition will be served on him within 2 days. Notice is registered on due date after 5 weeks. Please also list on this date. This one. So
Item 4.
yes, preliminary objection.
My lord, yes, my lord, as to the maintainability of the writ petition. Primarily on the ground that, my lord, filing this case here before the Honorable High Court, and then, my lord, locus of the petitioner to file the petition.
It says it's a territorial jurisdiction is lacking.
My lord, that's what they said. My lord, we have challenged the promotion policy, my lord. The promotion that is concerned, my lord, from executive cadre of E2 to E3 and E3 to E4, man. These two categories.
No, you see, there we find that there is some, what do you call, some issue, which is very, very particular, because in a service matter, right of a society to maintain a challenge, because it's only a aggrieved party who can challenge.
But
Yes,
it was a
policy-
collective order, my lord, no individual orders were passed. The orders that we challenged were collective, my lord.
The promotion policy, it can be challenged by only those persons who are who are aggrieved.
And there is a,
My
my
lord,
lord, I'm sorry to interrupt. There is a further perspective to what has fallen from your lordship. Most of the members of their own association are beneficiaries of the order impugned in this case.
no, no, that
Yes,
we
my
have,
lord.
my lord, we have made.
That is the other perspective.
No, 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 he is wrong, my lord. My lord, may I just show up? Kindly come to my lord, paragraph. Well, he has really overlooked it. That is why he is making this submission, I believe. My lord,
He's your friend.
my lord, my very dear friend, but still he has ignored this, my lord. My lord, that is paragraph. We have made also para 38 months of our writ petition. We have no grievance as to the promotion given to the 75%, my lord. Our case is that why are you leaving out this 25%? That is all. That is why we have not challenged, my lord. Para 38 may kindly be seen once. Page 35.
35.
Page 35.
Now, in this repetition, you have not given a list of your members.
List of my members, my lord.
It's not there.
My lord, ours is the association, my lord, that is
No,
taken
we
into
don't know.
confidence by the
but
respondent
you
corporation.
can't-
my lord.
No, no, we have seen this issues multiplying when it comes to the appointment of teachers and all. There are people whose name keep cropping up in the list. There are lists which gets expanded. just like my belly.
But this
There's-
cannot be done
There's
here, my
there's
lord.
there's
No,
fat,
no,
just goes
no, in
expanding.
the sense that, my lord, in E2 to E3 and E3 to E4, the members are already there, man. And all these members are represented by this association.
No,
These
no,
are-
members, we have to
Yes,
have a
ma'am.
list number one.
They cannot come again, my lord, just because one order is given in this,
No, no. These are,
any
members-
direction that goes from this court, my lord, will go as a collective, my lord,
no, no,
this thing, interest, my lord.
no, people who are not there can't get the benefit of, the reputation, notwithstanding whether the reputation is maintainable or not.
No, my lord, may I just make
35?
myself, my, your lordship, I'll first like to praise, my lord, that para 38, man, page
Para
35.
38. Yes, I'm there.
Page 35. Let me read it out, my lord. That the petitioner may state that while at this stage the petitioners do not intend to challenge the promotions that have already been given to the concerned officer who are also the members of the petitioner association. They have a very independent praise for direction from this honorable to promote the remaining officers, man. So there is no need to make them parties here. As simple as that, man. We are not pressing.
No, but if you are challenging it, you can't take the benefit of a law which you are challenging.
Your lordship will kindly come to Annex of 4, man. Yes, man.
Now it's a 4.
Yes, my lord. Annex 2, my lord. MOU
Page-
dated 4 in
page- page
2004,
number.
page 186.
186. Yes,
Well, there, my lord, clause number 3.5. 3.5 at 189.
3.5.
Yes, man. At
This-
page 189.
This is under challenge.
This is not under check. This is the very bedrock of my case, man.
Okay.
Your
Yes.
lordship will kindly see, this is an agreement signed by the ONGC management and the association, man.
Yes.
At the bottom, 189. Both the petitioners and the respondents are represented, man. Now,
Yes.
clause 3.5 says, over a period of time, concept of assessment system shall be evolved in consultation with ASTO for effecting promotions up to E4 level over and above the quantification system. What has happened, my lord? Earlier, my lord, they used to, my lord, assess all the incumbents in the particular cadre, namely, my lord, E2 and E3. E2 to E3 and E3 to and E4, man. Now, this time, my lord, they have changed the policy, my lord, without any consultation with us. That is the grievance. They have, without giving any criteria, my lord, they have picked up 75% of the employees, leaving out 25%. Since those 75% are also our members, my lord, so we are not challenging, my lord, their promotion. What we are seeking in this writ petition is that a direction to the respondents to consider this remaining 25%. That is all. That is the case. And they have not consulted with us, my lord, prior to giving effect to this.
Where is the impugn order? This impugn order.
My lord.
Is it-
15 and 18, my lord. Annexer 15 and Annexer 8. Huh? Annexer 13 and Annexer 18, my lord. Annexer 13 will be page 252. Annexer 13 is page 252, my lord.
So this, just let me understand.
Well.
Your hierarchy is perpendicular.
My lord.
E2 to E3, you have same vacancies in the, from E2 to E3,
My lord.
same number of posts are there. To accommodate 100%.
No, my lord, there will be some, already in E3, there will be some, it is not that, my lord, I must say the entire cadre will be vacant. It is
So
not
how,
that.
how your prayer can be considered by them if their vacancies are not there?
But that is not what they say, my lord. Because earlier, all 100% were, my lord, considered, my only this is the first time, my lord, they have picked up 75%.
252 and
252 and my lord, second is annexure 18, my lord, 269. For a moment, my lord, I would also like to draw your lordship's attention to annexure 15, my lord, at page 257. My lord, in furtherance of that clause 3.5, my lord, of taking us into confidence before declaring this policy, my lord, what they have done, your lordship will kindly come to page 257.
yes,
My lord, this is a reply in the Rajya Sabha, my lord, by the concerned Minister of Petroleum and Natural Gas,
yes,
page 258, my lord.
yes,
I would like to read out. Association of my lord, middle pyramid. Association of Scientific and Technical Officers, my lord, which is the Petitioner Association, has submitted a memorandum dated so and so. The association has mentioned that it is in unison with the management vision for merit-based promotion for ensuring leadership planning. Astro has taken the position that changes in recruitment and promotion policy of company be done only after consultation. My lord, your lordship will kindly note this. Only after consultation with the Officers Association. They have admitted in my lord. Consultation with association is a continuous ongoing process. Management met as a representative on 30/10/23. CP has a response to the shareholders and have no balance and have to balance efficient career progression in a human. This is okay, my lord. But they have not taken us into conflict for declaring this policy. Whereas they have, my lord, in Rajya Sabha, my lord,
Yeah.
such a house, my lord.
the consultation was done, they are not required to have your consent. Consultation was done.
No, my lord,
Consultation-
in keeping with this 3.5, my lord, nothing is done, my lord. Assessment system shall be evolved in consultation. So this was not done. That is the grievance.
No, consultation is that you're not given the,
No, my lord, here
No,
3.5
I'm
is
trying to
quite
understand.
clear, my lord.
Mr. Goswami, I'm
My
trying to
lord.
understand,
My lord.
have they abrogated their right? They have given it to the association, and now you decide what is to be
No,
done.
no, no. What they have said, my lord, my lord, it would have meant, my lord, we had the opportunity to place something from our side, my lord. That is all. Over a period of time, concept of assessment system shall be evolved in consultation with us. So nothing can be more clear. Than that. They recognize us, my lord. They have taken us into confidence, my lord.
But what about territorial jurisdiction?
My lord.
If the policy is
My
decided
lord,
that
the cause of action has arisen all over, my lord. Wherever the ONGC operations are going on, or ONGC offices are situated. And here, my lord, Assam asset is one of the largest ONGC assets, my lord, in the country. And they have authorized us, your lordship, I will just place those documents, my lord. Earlier, my dear friend had objected to all these things, my lord. And in fact, my lord, the maintainability, my lord, I am placing one order of this High Court, my lord. They had admitted with petition filed by this association earlier, your lordship. I am placing these two documents, my lord. One is a resolution taken by the Central Council, my lord, allowing the petitioner to file. Petitioner to file this case, my lord. And my lord, the second document is a order passed by this court, my lord, in WPC 1104 of 2011, my lord. Let them come out with the criteria, my lord, and allow us an opportunity. That is all, my lord. We cannot say that we can dictate the terms, my lord, at any point of time. We can never do that. It's not done earlier also. It is the employer's, my lord.
Yes, Mr. Chaudhary, on preliminary issue raised by you.
My lord, I'll come to the merits of the submissions. Straight away, my lord, to answer paragraph 38, if he is relying on paragraph 38, if this repetition is hit by the doctrine of approbation and reprobation. They cannot take advantage of part of a document and reject the rest which is not suitable. I can place a judgment straight away. But before that, if your lordship will first come to paragraph 1 of the repetition.
Yes,
That the petitioner is an association formed in the year 1961 by the name Association of so-and-so, got registered on 8/6/67 with Registrar of Societies Dehradun. Pausing here for a moment, well, registered under what provision of law? If it is the Societies Registration Act, section 6 will come in. Because now if your lordship kindly turns over to the next page, who has filed this writ petition is reflected in the last part of paragraph 1. Last sentence of paragraph 1, but at page 6. The
yes,
present writ petition is being filed through the authorized representative of the Petitioner Association who has been duly authorized by resolution taken by the ASTO Central Executive Committee in its meeting held on 4/3/24.
President Secretary.
Section 6 says only the President, Chairman and Secretary can file. Who is this authorized representative? On this count itself, the writ petition has to go. Now, now, my lord, the second aspect, as I was pointing out, is either, if your lordship will kindly come to the impugned, there are two things impugned in this case. Annexure 18, which my learned friend just pointed out, page 269.
Yes,
This says, list of executives recommended by the departmental promotion committees for empanelment with designation, etc., etc. Basically, this is an order of promotion. Now, if your lordship kindly turns the page to the next page, 270, your lordship will find from 270 till page 301, hundreds of officers have been promoted. All these officers are members of the same petitioner association.
We are not pressing that, my lord. I have
So,
made my
you-
point
you-
clear, my lord.
let it complete.
Either they can say that their policy is wrong. Therefore, these promotions are wrong because they are challenging the policy also.
No.
The first challenge is to Annexure 13. That is a challenge to the policy itself. If the policy, assuming I am making an assumption in his favor, assuming your lordship, after hearing the matter, arrives at a conclusion that this policy is wrong. Your lordship, as a because this order of promotion is a consequence of that policy.
Word ab initio.
So this policy also will go. Without hearing these persons, how can your lordship even enter in this writ petition? The clear case of non-joinder of necessary parties. Either he gives up a challenge to the policy, because this is a mere consequence of the policy. Now, there are other aspects, my lord. This writ petition is not maintainable on several grounds. Now, if your lordship sees the two orders, first order impugned is Annexure 13, page 252.
Just a moment. Yes,
No. If your lordship comes to page 252, your lordship will find that this order is this policy. decision was notified in Dehradun. Now, taking your lordship back to page 269, your lordship will find that this promotion order has been issued at New Delhi.
Now, I'm just forwarding you this data which he has shown us. I have underlined a particular word. A particular part of sentence I have underlined. Would you still oppose?
I wish part of that would come to me also.
This is privilege.
No, not that, I'm just asking him. You see,
That is the reason he did not annex it to the.
no, once you see the advantage of knowing both of you, is that I can laugh at least smile from the beginning of the day. Otherwise, it is monotonous. So, knowing both of you and knowing that both of you will not take an offense, I just said it.
Never.
So, my lord, there is no statement your lordship will find in the entire writ petition. One, the policy itself was notified in Dehradun. The promotion order impugned, which they are saying now, saying that we are not challenging as such. We are saying that these 75% are also our members. Consider the remaining 25% also. I'll come to the merits of the whole case a little later. Now, there is no statement in the writ petition anywhere that it is only the employees serving in the state of Assam who are agreed. Otherwise, the territorial jurisdiction is purely within New Delhi and Dehradun. Now, coming back to the point of the policy itself. My learned friend pointed out clause 3.5 of the MOU of 2004, saying that there was an arrangement that the petitioner association will be consulted. On facts, my lord, your lordship will come back to page 252, the order impugned first, and your lordship will now have a look at the contents of the policy.
Yes.
Before I take your lordship through the contents, I must indicate one aspect, vital aspect to your lordship, the reason and the purpose behind this policy. Your lordship is aware, gradually ONGC, IOC, Oil India Limited, etc., they are not just like in the past, PSU functioning independently. Nowadays, there are a lot many private players who have entered the market. So we are now having to compete with private operators also. Secondly, gradually there is a shift towards renewable energy also. So the whole dynamics of the energy industry has started changing. In this context, what was happening was earlier from these levels, these cadres, the promotion used to be very mechanical. If you have the eligibility criteria, you automatically will be considered for promotion. By doing this, what we have done is we are bringing in an element of inter se competition, that the 75% of the best people will get promoted. Your lordship will kindly see, in this context, your lordship will kindly see the policy. ONGC Board of Directors in the 372nd meeting held on 25th October, etc., at New Delhi, accorded approval for modifications in criteria for promotions from E2 to E3 and E3 to E4 levels, effective from 1/1/24 onwards as under. Number one, top 75% of employees who are considered for promotion will be promoted with designation to the next higher level. Existing provision for cutoff marks for next pay scale, that is 11 marks less than last qualifying marks for promotion with designation to continue. Change in the weightages given for PAR and experience. PAR weightage in the promotions is increased to 60 marks from the current 50 marks. Experience marks is reduced to 20 marks from 30 marks. What we are doing is, merely because you have the experience will not be enough. PAR is performance appraisal. We will make an assessment of your performance also. And your lordship is aware, in all promotions, performance is an integral part of assessment. We are raising that too by merely 10 marks. So if your lordship peruses this policy, your lordship will, it becomes very clear that it is those persons who did not attain that performance appraisal who are before your lordship. The other 75%, who are the larger chunk of the beneficiaries as per the impugned order, who have already got the promotions, they may not even have agreed to pass this resolution to prefer this writ petition. That is another reason why these persons from page 270 onwards are necessary parties. Whether they at all approved this organization to file this writ petition. Now, my lord, their main thrust is that we were not consulted. Your lordship will kindly come to Annexure 11 at page 234. Your lordship will kindly see the heading. Minutes of the meeting of bilateral meeting with ASTO, that is the petitioner, held on 30th October 2023 at New Delhi. And if your lordship kindly turns to first to page 241, this is 2 months prior to notifying the policy one, which is under challenge.
Page?
Page 234.
Hmm.
And thereafter 241. If your lordship sees page 234, the chart starts at 234 itself. Discussions on agenda points. And on the right is the thereafter, my lord, serial number, agenda, deliberation, discussion. Now, if your lordship kindly comes to 241.
I checked up. In fact, something was ringing in my head. 30 October is International Drama Day.
That is how the Perhaps the drama is still continuing, since it started on 30th of October. If your lordship will kindly come to 241, last serial number 34 on that page, right at the bottom.
Yes.
Your lordship will kindly see the agenda. Review of PAR process. So in their presence, it was made known that we'll be reviewing the PAR process. And towards the right-hand side, what was the discussion? It was informed that an agency has been engaged by ONGC to review existing HR practices comprising of performance management processes, succession planning, recruitment and promotion policy, job rotation and transfer policy, knowledge management policy, and identify areas for improvement that needs intervention for enhancing agility, productivity and efficiency, leverage learnings and adoption of the best practices from global and Indian peers, etc., etc. ESTO expressed concerns over system-based restriction on awarding outstanding rating. ESTO opined that such restrictions are demotivating field personnel, etc. So ESTO was very much part of the deliberation. Now, my lord, serial number 36, review of recruitment and promotion policy. It was informed that the existing promotion policy is under review based on organizational requirement and recommendations of the consultant. The existing promotion policy is being reviewed with the focus on linking promotion with performance. The following proposed changes were shared. Introduction of promotion based on giving merit to performance for E2 to E3 and E3 to E4 level, wherein 75% of eligible executives will be promoted based on PAR experience and qualification. However, the practice of giving pay scale next level to the executives will continue who scores certain marks. So we have not outrightly denied them everything. So performance appraisal will be considered for the purpose of promotion, but pay scales will continue. Introduction of ADC is proposed to be introduced for consideration for promotion, etc. We are not really concerned. So it is wholly incorrect to say that they were not consulted. On 30th of August, they were present when these things were discussed, and pursuant to this, the amended policy was notified in December 2023. And based on that, in December 2023, the policy gets notified. In March 2024, the promotions are effective. They wait.
Just give those dates again.
My lord, this meeting was held on 30th of October, 2023.
Yes.
The revised promotion and recruitment policy was notified on 26/12/2023. It is not challenged. On 19th of March 2024, after the DPC conducted this humongous exercise, ONGC is a massive organization. Your lordship has seen the number of promotions that have been given. Hundreds of promotions. So the DPC undertakes this huge, humongous exercise. Does this election in March, and they file the writ petition in April. Why didn't they, if there is something wrong with the policy, why wasn't the policy challenged immediately?
Nineteen 3/24 is the date of promotion order.
Promotion. Which is very half-heartedly challenged in this writ petition. Hold on. 67 September.
Yes.
Now, my lord, on facts, I have demonstrated that it is not correct to say that they were never consulted. They were consulted. But what is the law? Let me place the judgment straight away. There is a constitution bench judgment which says that the employer has the absolute prerogative to fix the criteria. You don't like it, you resign and go. Go and find yourself a job somewhere else. Who are you to tell the employer, that this should be the criteria. We have been nice to you, we have been kind to you, that we have kept you in the loop. The law says, as far back as in 1967, that there is no need whatsoever. It is the prerogative of the employer. But the language used, I would just like to trouble your lordship with one paragraph. The citation is AI 1967 Supreme Court 1989.
What is this case?
Roshan Lal Tandon versus Union of India. book list दिया नहीं था। This judgment pertains to the railways. Here also a similar
1984
1989.
9. '67
67.
1989.
19.
Not coming up. Roshan Lal is one word.
Roshan is one word. Lal Tandon. TANDON. Roshan is ROSHAN.
No, Tandon TANDON.
I am sorry, my lord. It might be 1889 because
this side.
in two places there are separate page numbers given. It
One-
is 1889.
1889.
Hmm?
You're not sure which case it is.
I am sure. AR is not sure.
Yes.
Your lordship may kindly turn to para 6 at page 1894. Here also a change in policy was questioned.
Yes.
We pass on to, has my lord got it, para 6. We pass on to consider the next contention of the petitioner, that there was a contractual right as regards the condition of service applicable to the petitioner at the time he entered grade D, and the condition of service could not be altered to his disadvantage afterwards by the notification issued by the Railway Board. It was said that the order of the Railway Board dated 25th January 1958, Annexure B, laid down that promotion to grade C from grade D was to be based on seniority cum suitability, and this condition of service was contractual and could not be altered thereafter to the prejudice of the petitioner. In our opinion, there is no warrant for this argument. It is true that the origin of government service is contractual. There is an offer and acceptance in every case. But once appointed to his post or office, the government servant acquires a status, and his rights and obligations are no longer determined by consent of both parties, but by statute or statutory rules, which may be framed and altered unilaterally by the government. In other words, the legal position of a government servant is more one of a status than of contract. The hallmark of status is the attachment to a legal relationship of rights and duties imposed by the public law and not by mere agreement of the parties. The emolument of the government servant and his terms of service are governed by statute or statutory rules, which may be unilaterally altered by the government without the consent of the employee. So this is the law. So, how are they, what is their legal right to prefer a writ petition, seeking a mandamus, saying that we have not been consulted and a change in policy has been made to our detriment. 25% are being left out. And therefore, your lordships will entertain the writ petition and issue a mandamus. In my humble understanding, my lord, it will be stretching it a little too far if such kind of petitions are even entertained. Because tomorrow everyone will say that the rules have been changed without consulting me. All employees will start filing writ petitions saying that the rules have been amended without any consultation. So far as ONGC is concerned, this is the manner and method in which the policy is notified. It is placed, once a change is suggested, it is placed before the board approves it, and relevant amendments are made to the regulations. So therefore, my lord, looked at from all perspectives, be it on the issues of maintainability or on merits, there's absolutely nothing in this writ petition, my lord, deserves to be dismissed. So, at this stage, my lord, I will leave it to your lordship. Since we have already filed an application for, already filed an affidavit raising preliminary objections, your lordship may either adjudicate on the preliminary objections, or else your lordship will may issue a notice keeping the issue of maintainability open and with an observation that this will be heard before any adjudication on merits.
Yes.
My lord, in reply to what my learned friend has just submitted, my lord. First of all, my lord, section 6 of society's registration. My lord, what he has submitted is very correct, my lord, except for the second part of it, my lord, which is not spelled out.
Society's registration. Please read.
My lord, it reads, my lord, every society registered under this act may sue or be sued in the name of the president, chairman, or principal secretary or trustees, as shall be determined by the rules and regulations of society. And here he has stopped, my lord. He has not gone further. Now, my lord, let me complete the entire sentence. And in default,
Yes, please go.
in default of such determination, in the name of such person as shall be appointed by the governing body for the obligation. This part was not read out. Here in this case, my lord, the person representing the association, my lord, is authorized by that, your lordship, that
My lord,
document, my lord.
I'm sorry to interrupt.
Yes, that's
And my lord, next, my lord, my friend has taken your lordship through the deliberation of 3010, my lord. Page 234, my lord, annexure 11.
page.
Page 234, annexure 11, my lord. This is a minutes of meeting of bilateral meeting with ASTO held on 30th of October 2023 at New Delhi.
Just one page.
Page 234. of the-
Yes.
While my pleadings in this respect is contained at para 26, my lord, I will just take your lordship to one particular portion of it, page 242, my lord. Page 242. Clause 36,
Yes.
which speaks of review of recruitment, deliberation on review of recruitment and promotion policy.
Yes.
It was informed that the existing promotion policy is under review based on organizational requirement and recommendations of the consultant. The existing promotion policy is being reviewed with the focus on linking. This is of 3010. Still being reviewed, not finalized. Your lordship now come to page 252.
Yes.
252 is the annexure 13, my lord. The declaration of their policy. Has your lordship got it?
Yes.
While this office order is dated 26th of December, it speaks of their approval given on 25th of October. That is, Your Lordship will kindly, I am reading out. ONGC Board of Directors in its 372nd meeting held on 25th of October 2023 at New Delhi. So they misled us, my lord, into believing that that was still being reviewed while they had already approved it on 25th of October, my lord. They issued this office order on 26th of December, my lord. But they approved the policy on 25th October itself and then held a, my lord, sham meeting with us on 30th of October, where they said that the policy is still being reviewed. My detailed pleading is at para 26. At page 27 of the writ petition. May I read out, madam?
You have a copy of your, what do you call it, the memorandum of your society? Do you have a
I
copy?
can get no association. No association. But we can get it. The constitution is with us. Constitution. Huh? Okay. Some portion may not be so legible, man. We can get, you know, video. Which is labor commission. और ये देखो, ये देखो, ये देखो।
Yes, okay.
In this connection, I would also like to place. Which shows that they recognize us and my lord,
But this is a document you are producing now, goes against your interest.
my lord.
This document which you have forwarded, this one, it goes against your interest.
No, no, that is to show, my lord, that.
No, but it confirms what Mr. Chaudhary has argued.
My lord,
You have forwarded a letter dated 10/4/2024.
my lord. Your lordship will kindly see the last line, my lord. It is.
No. I start from beginning.
My lord,
Come to second paragraph.
yes, my lord.
This association has more than 70% of total executive strength as its members.
Yes, my lord. And one of the oldest associations.
No.
Yeah.
70%, not
Yeah.
all.
My lord,
That's why when we first go, we ask you to give a this list of officers.
my lord.
So therefore, your association itself accepts that it is 70% of the executive strength.
My lord,
So all are not your members. Once they are not your members, your reputation fails. Some people will have been promoted without challenge. Their promotion can't be.
but
what you call-
promotions we have not, shall we made myself.
No. You have no scope of not
Fine.
challenging it. Once this, let us say that today we are quashing it. Promotions can be saved. Let us say we are agreeable to what you are argued. We are heavily against Mr. Chaudhary.
We have
We
raised
allow
no
your
objection,
repetition.
my lord, to,
No, no,
to the
we allow your
respondent.
repetition.
My
The
lord.
policy goes. Promotion can't be made on a policy which doesn't exist, because when we crash it, the crashment goes to the root of the matter. It is wide ab initio. You can't save what has been done. We are not parliament or assembly where we can save in under repeals and savings provision. Actions already taken. We don't have the authority to do so.
Well, today, my lord, it has come for the maintainability, my lord. My lord, let them come or affidavit will
No,
reply
that's
to
not,
them.
this one thing I need.
We'll-
You
we'll
have provided
reply
that. Your requisition will not be maintainable.
And
That is why, in fact, he is relying on the second part of section 6. What does second part of section 6 say? The governing body by resolution has to authorize. That governing body resolution is not even annexed. How do we know whether there was quorum in the governing body?
those are,
Well-
that, my lord, my lord,
No,
produce
no.
it. I can produce
Those
it.
are
That is
required
not
to
an
be.
issue, my lord.
Otherwise, how do I
Not
even
an issue.
Address it. Address
defend?
it.
All these things need to be placed on record.
No, we'll not dismiss on that ground, but this, we find point in your submission that the replacement is not being maintainable here. Third, Mr. B.D. Goswami done it. Counsel for the petitioners. Also heard. CGC, you are there, Mr. No, Mr. Bora. Mr. Bora, you are there as CGC? Will be there in the matter then? Miss A. Gayan, okay, we will record her name.
They are just a formal party.
Miss A. Gayan, then it's CGC appearing for respondent number 1. And Mr. You are appearing for all?
2 to 6.
Mr. I Chaudhary, learned senior counsel, assisted by Mr. B. Chaudhary, learned counsel for respondent numbers 2 to 6. Next one. By this repetition file under Article 226 of the Constitution of India, the petitioner has assailed an order dated 26/12/2023 issued by the General Manager within bracket HR, corporate policy within bracket respondent number 6.
My lord, if I may, my lord, my friend says, my lord, on this, my lord, this is a letter from the ONGC, my lord, the 10/4/24. So, my lord, he seeks an opportunity to get his association's instructions, my lord, on this, my lord. Whether your lordship has point second panel, my lord.
You either withdraw it because I won't wait for instructions, because that is not permissible. When the writ is there, we have taken possession of the matter. We will not be dictated by the association what to do. We can't be dictated by the association what to do. When you have heard the matter, you have spent more than 1 hour.
My,
No, you have to- as well as communication dated 19/3/2024 issued by the Executive Director, Chief HRD ONGC within bracket respondent number 5. That's right. So both the orders under challenge. The aforesaid order and the communication, which are under challenge, are quoted below. Next. Page 252 and 269. Next slide. The petitioner is an association representing the executive cadre of officers of Oil and Natural Gas Corporation Limited. The letter of authority to empower the deponent to file this writ petition by resolution adopted by the Central Executive Committee in its of the petitioner held on 4/3/2024 is reduced in course of hearing. First, the learned counsel for the petitioner association has submitted that there was an memorandum of understanding between the association of the petitioner and the ONGC management which was signed on 4/8/2004, among others, envisaging participation of the petitioner association in the deliberations.
The assessment process.
Huh?
In the assessment process. 1/6.
Where is that?
On page 186, 189, my lord. 189. Clause 3.5, 189.
In the
Assessment.
consultation process, while preparing the recruitment and promotion policy, full stop. It is further projected that in the consultation process, which was initiated for a change in policy of promotion, a meeting was held with the petitioner association and the management of ONGC on 30/10/2023, wherein an impression was given that the that the existing promotion policy is under review. Full stop. However, in the contrast, it appears from the impugned office order number 26/2023 dated 26/12/2023 that the Board of Directors of ONGC in its 372nd 2 meeting held on 25/10/2023 had already given its approval for modifications in the criteria for promotions from E2 to E3 and E3 to E4 levels, effective from 1/1/2024. According to the Learned Counsel for the petitioner, the consideration of promotion would be limited to consideration for top 75% employees with a cutoff marks for the next pay scale, as well as changes in the weightage, and change in weightages given for performance appraisal and experience. It is submitted that the said modification in criteria was not in consultation with the petitioners and therefore conditions which are adverse to their interest was implemented. For which the present challenge has been made. Next slide. Right, order dated 1/5/2024, the senior counsel for the respondent numbers 2 to 6 had raised a preliminary issue by filing an objection on 30/4/2024, and accordingly, on the issue of maintainability, the Learned Counsel for the petitioners has submitted that the officers of the Assam asset have come forward to challenge the said amended promotion policy and the deponent who has sworn the affidavit in support of this writ petition has been empowered by way of resolution dated 4/3/2024 by the Petitioner Society to file this writ petition. Just put on hold here. This paragraph will come later. When you said that the challenge was made as per order 5/1/5, after that is right. Agitating the issue of maintainability, the Learned Senior Counsel for respondent numbers 2 to 6 has submitted that the meeting for consulting the Petitioner Association was held on 30/10/2023 and the Petitioner Society was informed of the reasons why the change of promotion policy was required. Referring to the minutes of meeting held on 30/10/2023, within bracket annexure 11, bracket closed, comma, agenda number 34 and 36, which was read, to show that the promotion policy was on account of review of existing human resources practices with several parameters which are mentioned in agenda number 34. And by referring to agenda number 36, it is submitted that while the promotions would be affected to 75% of eligible executives based on performance appraisal, experience and qualification, but the interest of other executives were also protected by giving pay scale of next level to the remaining to all the executives who score certain marks. So accordingly, it is submitted that the policy was reviewed with focus on linking the promotion with performance. Full stop. In this regard, by referring to paragraph 6 of the case of Roshan Lal Tandon, TANDON, versus Union of India and another, Union of India and others, AIF 1967, SC 1889. Now it is submitted that the Constitution Bench of the Supreme Court of India has held that once a person is appointed to his post or office by the government, the government servants acquires a status, and his rights and obligations are no longer determined by the consent of both parties. But by statute or statutory rules, which may be framed and altered unilaterally by the government. It is submitted that the same principle would apply in the affairs of the respondent number 2 corporation. And therefore, it is submitted that although a consultation process was as envisaged, which was also done, but the members of the Petitioner Association cannot dictate the policy to the respondent to corporation. So it is submitted that the law which has already been laid down by the Supreme Court of India would disentitle the maintainability of this. It goes to the root of the matter, and the writ petition would not be maintainable. Full stop. Next one, it is also submitted that the consultative meeting was held on 30/10/2023, and the revised policy was notified on 26/12/2023. During the set, and after that, the Departmental Promotion Committee commenced its exercise to promote eligible officers, and the promotion order, which is annexed to this writ petition, as an appendix to the communication dated 19/3/2024 within bracket annexure 18. As annexure 18 capital A contains names of how many people are there, you say?
Hundreds. It is difficult to count because my lord, they are in different categories.
Oh, okay. Hundreds of officers of the ONGC have been given promotion at different levels. This was accordingly it is submitted that the Petitioner Association did not come at the earliest moment and allowed the promotions to take place. And thereafter, the present writ petition has been filed. So that one it is submitted that in paragraph 37 of the writ petition, a specific plea has been taken that the officers already got promotion.
It will be, there are 38.
38. The Petitioner Association is not acceding. The promotion of those officers who have already been given promotion. Accordingly, it is submitted that if this court sets aside the promotion policy, it would have adverse effect to the officers already promoted, as those promotions cannot be saved. It is also in the said context, it is also submitted that the writ petition is bad for non-joined or necessary parties, as the officers who have been given promotion are not aided as respondents, and orders to their adverse orders to their orders adverse to their interests cannot be passed without giving them an opportunity of being heard. Next para. Further challenge to the maintainability of the petition is raised by submitting that the Petitioner Association is registered in Dehradun, and the head office of the respondent number 2 is at registered office is situated at Delhi, and the policy was issued from the corporate policy section of the respondent number 2 located at Dehradun. Accordingly, it is something that either the courts at Delhi or the courts at Dehradun alone will have the territorial jurisdiction to entertain the challenge made in the writ petition. Next one. Countering the point of maintainability raised by the learned counsel, the learned senior counsel for the respondent number 56. The learned counsel for the petitioner has submitted that. Now that will be added, first part. Next, second, it is submitted that the Assam asset has a large number of officers, and therefore more officers of the Assam asset will be affected by the policy, and therefore the present writ petition would be maintainable, as the respondent number 2 has an office at Assam. It is something that there is already an agreement between the Petitioner Association and the ONGC to include the Petitioner Association in the consultation process. And as the decision to amend the policy was already taken on 25/10/2023 by the Board of Directors of ONGC in its 372nd meeting. The consultation process was only a eyewash. First one. It is reiterated that it is submitted that the statement made in paragraph 38 of the writ petition would make it clear that the Petitioner Association is not challenging the promotion already made. And the purpose of filing this writ petition for a direction by this court to promote all the remaining officers of the cadre of E2 and E3 level would otherwise be deprived of promotion by the unilateral decision of the respondent number 2 corporation. Hence, it is submitted that there is no requirement to include the officers already promoted as respondents, and they would not be materially affected by the clear made in this writ petition. Next paragraph. On the point of maintainability, having heard heard both sides, this court is of the considered opinion that the Petitioner Association is having its offset in New Delhi. no, sorry, Dehradun.
Registered office
And
in Dehradun.
its headquarters at New Delhi.
and New Delhi.
And that the challenge in this writ petition is not only for the officers of the Assam asset, but the nature of challenge made in this writ petition, which is directed against the office order dated 26/12/2023 and the communication dated 19/3/2024 cannot be said to be limited to the officers of the Assam asset. Therefore, explicitly it appears that the territorial jurisdiction for this challenge will not be within the territorial, within the jurisdiction of this court. Next para. On the next para, on the issue relating to non-general necessary parties. This court is of the considered opinion that in the event the office order dated 26/12/2023 and the communication dated impugn communication dated 19/3/2024. First thing is annexure 13. First is 26/12 is annexure 13. Second, 19/3 is annexure 18. Are interfered with. There is no way that the promotions which have been made subsequently on 17/3/2024 in accordance with the new policy, the new promotion policy can be saved. Therefore, the officers who have been promoted on the basis of office order dated 26/12/2023, while orders passed, promotion orders passed on 17/3/2024,
In the 19. Should be 19.
19,
19.
17, 18. Privacy cannot be saved. There is no doubt that without setting aside of this policy, no effective orders can be passed by this court to direct promotion of 25% of the remaining persons. The officers at the scale of E3 and E4. E2 and E2 or E3?
E2 to E3, E3 to E4.
E2 and E3 scale. Next paragraph. Therefore, on the ground of non-joint or necessary parties, this representation fails. Next paragraph. Although the court is not entertaining the petition on merit, but as the constitutional bench judgment of the Supreme Court of India in the case of Roshan Lal Tandon, even that Supra has been cited. It will only be appropriate that the paragraph 6 on which reliance is placed is quoted below, without any observation of the court on the on the merit of this matter. Full stop. The reason for quoting the said judgment, the said part of the judgment is only because of the fact that the Constitution bench of the Supreme Court of India having observed that the right of the employer is available to unilaterally change the policy, comma, it being a law which is required to be followed by applying the principles of Article 141 of the Constitution of India has to be considered. And public considered when the matters, when the issue like this is it crops up. Full stop. Next continue. Same. How it is made clear that the observation is only a passing remark and would not constitute any decision of the court on merit. Full stop. Next. Therefore, on the preliminary issues raised by the respondent numbers 2 to 6, this revision fails and the same is dismissed. Just one more thing. On non-gender, where I've said non-gender, there you add another paragraph. In course of submissions, the learned counsel for the respondent numbers, sorry, the petitioners, petitioner association has placed copy of letter under file number 30 within bracket 1 bracket close oblique 2024-IR dated 10/4/2024 issued by the DGM within bracket HR bracket close dash IC in charge I/C full stop corp CURP full stop capital IR and addressed to the Deputy Chief Labor Commissioner within bracket Central there is an observation made in paragraph 2 of the said letter that the petitioner association has more than 70% of the total executive strength as its members. Full stop. If all the officers are not its members, it would not be open to the petitioner association to lay challenge to a policy, promotion policy, which affects persons who are not their members. Therefore, without adding those persons, those officers who are not the members of the petitioner association, the present challenge would also be not be maintainable on the ground of non-general and necessary parties, as the petitioners cannot be permitted to espouse ESPOUSC, their call, the cause of their non-members. Photocopy of this said communication dated 10/4/2024. This will be next time, and the copy of the resolution dated resolution Let's check our misplaced symbol. Written as a part of the call. You can then post it.
Deeply like.
Well, your lordship has very well described the situation as it is, my lord. And may I just make a prayer, my lord, to the extent that they will not be without liberty to, my lord, to consider the case of this remaining.
No, after that we can't do it. The only thing we can give a concession is that this order will not preclude you from challenging it by removal of these defects.
Yes,
Ah,
it
that
is not
liberty-
done, but yes,
That liberty will always be there.
my lord, that,
Next, the dismissal of this petition on preliminary issues shall not be a bar for the petitioner association to file to approach the jurisdictional high court. By reviewing those defects, if so advised. I'll take a break and come back.
but
Lordship, we have the instructions, Lordship. Here, we'll require 30 days time, Lordship, to process. We have already paid an arrear salary amount to 82 lakhs. Now, only a brief stint of 1 year period, my lords, that has been misplaced. That process has been initiated. And the non-practicing allowance of the petitioner has also been finalized. So the department is seeking 30 days time to complete the process to comply with the court's order, Lordship. So I have informed the same to the petitioner also, my lords. If a date can be fixed, Lordship, we might be able to finish the process earlier than that, but Lordship, yes, Lordship, but we'll try to finish it before that. And I've informed the petitioner also, Lordship, so that
Lordship. 1 month, okay, Lordship, yes.
Lordship, if Lordship desires, I can give the communication, hand over a copy of the communication to the. Lordship, he has my contact number also. So Lordship, he has my phone number also. So Lordship, that I'm trying to coordinate with the petitioner in person.
Mr. A. Shalia Leonard, counsel for the respondent. You have a respondent number?
1 and 2, Lordship, both
The
the.
respondent numbers 1 and 2. I'll produce a copy of the instructions dated 4/5/2024. Stating that The area salary of rupees 82.0 82,02, 578 towards aerial salary has for the period of 1/1/1996 to 29/2/2016 has been paid to the petitioner in person. And proposal has been sent to the finance department for payment of area salary of rupees 1,09,328 for the period from 1/7/1997 to 6/1/1998. And that the Accountant General within bracket A and E bracket to Assam has already authorized the principal chief superintendent, Assam Medical College and Hospital, Dibrugarh, to make payment of non-practicing allowance and the said authority has already initiated the submission of bill to the treasury for payment of non-practicing allowance. Post by the said communication, 30 working days time is for the requested to is desired for compliance of the order of this court. Next level. The petitioning person has no objection to the grant of time. It's accordingly this form, give a date after 6 weeks. This term so by which time the respondents would do the needful for compliance with the order of the lodge. 26 June. The instruction for this is made a part of the contract,
So I've also handed over a copy of the instruction to the petitioner.
which has already been also been handed over to the petitioning person. Okay. Item 12.
By the description, I have challenged the model input minutes of the meeting of the SLC model, family page 104. Whether the model stating that model the applicability of the office memorandum 1/6/2015 have no retrospective effect. But in earlier occasion, my lord,
No, but you see this, this is 2000, you
15, my lord,
you died, your predecessor interest died when?
my lord, 6/4/2015, my lord. And within 1 year, my lord, the petitioner filed application 27/5/2015.
But still, in view of the recent judgment of the Supreme Court where it says that once there is a delay,
But in that case, my
even on part of the, even on part of the respondents,
and now, my lord, I
not
have
condemnable.
challenged the minutes, my lord, and the state level committee after long time of, well, first, my lord, placed 3/9/2022, my lord,
3/9/2022.
22, my lord, first SLC meeting. And kindly see, my lord, page 7 or page 32. Operative page 33, my lord. Is stating that, my lord, the government servant has balance of minimum 3 years of service as point number 1 rejected, my lord. That's why. Subsequently, my lord, this honorable court, my lord, approved before this honorable court, and this honorable court, my lord, set aside that point number 1, my lord. In Bhaskar court case, my lord.
Yes,
That was pending before the division bench, lordship. And stay order is there, lordship.
And my court order kindly see page 97. This honorable court directed the state level committee to consider the case of the petitioner afresh without insisting the point number 1. Page 99, madam. And thereafter, impugns minors were finally case 104, where is stated the OM dated 1/6/2003 had no retrospective effect. But in Supreme Court judgment, and Santosh it categorically stated that the policy applicable at the time of consideration of the petition application 2027 SCC 617
What is the citation? Please give again.
2027 SCC 617. That I provided.
Yes, what is your plan?
Lordship, as per the.
This that notice may be issued, my lord.
Issue notice, Lordship.
Because writ appeal also pending, before the honorable court,
To issue notice? Okay. But may Mr. K. R. Padgiri and counsel for the petitioner, as well as Mr. A. Chakravarti and government advocate appearing for
all the
all the respondents. Next, I mean, consideration of candidature of the petitioner for appointment on compassionate ground. The present petition has been filed under Article 226 of the Constitution of India. You notice, we turn over in the date after 4 weeks. Requisite extra copies of the petition is out of the government advocating course of the day. Next, this one, so.
Obliged.
Take back your citation.
Time being item 7.
Yes, Mr. Adhyapak.
This matter also, my matter is also similar to item number 12.
Okay.
Lordship,
We issue notice.
Your Lordship, kindly consider the devoto Tiwari judgment. Here, immediacy is
No,
a
but once we
concern.
have, in
Lordship.
one case, we have issued the notice.
Lordship, in terms of item, order pass in item number 1, Your Lordship, that's why.
This
It's
is
okay.
Also, Your Lordship, if I may state, there has been delay in filing this writ petition also because the SLC minutes is of 2022. And they are here in 2024. There also immediacy is of primary concern.
one affidavit not second this.
Is withdrawn with liberty.
Yes, sir.
Issue notice of. Same order, Mr. Adhyapak, counsel for the petitioner. Father died in harness on 6/8/2014. Mr. D. Bora, government advocate appearing for all the respondents.
All the rest.
Item number 8 is same. Item number 8 is also same.
8 is also same. Here, what is the date of death?
18/8/2016.
18/8/2016. Look at that. Mr. Bora. Item 9.
Obliged.
Item 9.
Please, your lordship.
He has come before the court, Lordship, after 9 years, Lordship.
My lord,
Kindly dismiss the petition, Lordship. It's covered case by Debobito Tiwari case, Lordship. DLC also not recommended, Lordship. I think, Lordship.
Well, I have not been informed regarding the outcomes of the DLC, whether my case is placed before the DLC or not. That is also, my lord, not informed me well. But department process to the, my lord. DLC.
Compassionate appointment can be made, Lordship, due to date of the financial hardship, Lordship. The sole bread earner of the date after the date of the sole bread earner, Lordship. In this case, Lordship, he has got all the benefits, Lordship. Kindly see the annexures, Lordship.
No, we'll issue an notice, you'll respond on the next date. We'll now consider on that date.
He has received the amount of, Lordship, family pension. This year's a gratuity, Lordship. Yes. Kindly see the annexure 7, Lordship.
Even if somebody applies on the next date and approaches the court on the third date, still you will not deprive that person of those DCRG and leave salary and all those things he is entitled to get. But once in 2 cases, we have issued a notice, 3 cases, we are not dismissing it now. Item 1 was different because it came for the second time. Item 1, notice we had already asked them to respond, therefore they responded. Same order. Same slap, asking for the petitioner, died in harness on, what is the date of that?
29/8/2015.
29/8/2015.
15. And he applied 15/10/2015.
It's not for the petitioner. It's a each authority, government advocate appearing for the respondent.
1, 2,
Number
5,
1.
and 6.
1, 2, 5, and 6. And Mr. P. Hendik, standing counsel for PNRD department, appearing for respondent numbers 3 and 4. Same date, you respond on the next date.
Item 14 with item 56.
Yes.
Your lordship, may kindly pass about the matter for time being. Mr. Deenat is in this matter. He is on legs in some other court, your lordship.
Lordship, I have,
After some time, your lordship.
Lordship, I have taken consent from Dean at Lordship. What happened, Lordship? Item number 56, we have filed earlier challenging a recruitment process on various grounds, Lordship. In that case, respondents has filed a affidavit in opposition. In that from the opposition, Lordship, it has come to knowledge that the recruitment process was conducted by a wrong committee, Lordship. Subsequently, we have filed another writ petition, which has come as item number 14, Lordship, challenging the selection committee, Lordship. That has come from motion hearing, Lordship. So Lordship kindly may issue notice in item number 14 and both the matter can be heard on Friday next, Lordship.
What is the wrong committee? Let us see. What do you say is the wrong committee?
Wrong committee, Lordship.
Here is that.
Lordship, if your Lordship come to affidavit in opposition, Lordship.
Item
Item number 56, Lordship.
56.
No.
Yes, which page?
Page number 98, Lordship, annexure A, Lordship. Affidavit in opposition filed by respondent number 3, Lordship.
Yes.
Annexure A, page number 98, Lordship.
Yes.
This is a letter sent by the member secretary of State Child Protection Society, Lordship. With reference to the subject cited above, I would like to inform you that various positions of contractual staffs under Mission Bachilo are lying vacant at state and district level. The vacancy status is enclosed herein as Annexure A along with the details of the post as Annexure B. In this regard, you are requested to kindly conduct a recruitment process to fill up the vacant position, Lordship. This was a letter sent by the member secretary to the Director of Women and Child Development, Assam, Lordship.
Yes.
Subsequently, thereafter, Lordship, Annexure 99, page number 99, Lordship. The
Yes.
Director of Social Welfare has, Director of Women and Child Development constituted a committee to, in the interest of public service and for smooth conduct of examination for various positions under Mission Bachelo in pursuance of letter received from Member Secretary SCPS Assam height number so and so, dated so and so. The selection committee is constituted with the following members.
Yes.
So this is the selection committee constituted by the Director of Women and Child Welfare.
Yes.
And this committee has conducted the recruitment process, Lordship. Lordship, in that brief, Lordship, there is a guideline of Mission Bachelo, Lordship. That guideline is there, Lordship.
Which page?
No, I have not, it was submitted, it was furnished, Lordship. It was circulated by letter dated 5th of July 2022, Lordship.
Yes.
Yes, Lordship. If your Lordship come to page number 60, Lordship.
Yes.
This is a selection process of staffs under District Child Protection Unit. A selection committee constituted by the State Principal Secretary headed by the District Magistrate shall head the selection committee for selection and appointment of staff of DCPU. DCPU is District Child Protection Unit, Lordship. The District Selection Committee may include district level officers, for example, District Program Officer, ICDS, District Social Welfare Officer, Chairperson, members of CWC, member of JJB, etc. Once the District Child Protection Officer is appointed, either by deputation or contract, he shall also be part of the selection committee for appointment of other personnel of DCPU. So, according to this guideline, the Principal Secretary need to constitute a committee to select the contractual staff of DCPU, Lordship. And as per this guideline, Lordship, if your Lordship come to my reply, affidavit in reply, Lordship.
Yes.
Page number 151, Lordship, in Annexure 1.
Yes.
As per the guidelines, Lordship, this committee was constituted in suppression of all previous notification order on the subject and in pursuance of the Mission Bachelo implementation guidelines issued on 5th of July 2022, and in order to select contractual staff in various positions of District Child Protection Unit and Government Run Child Care Institute under Mission Bachelo, a district level committee is hereby constituted consisting of the following members. These are the members, all these members of district level, Lordship, Deputy Commissioner, Superintendent of Police, etc., etc. And the District Child Protection Officer is also a member of this committee. And after this constitution of committee, Lordship, page number 153, Lordship.
Yes.
Same member secretary informed all the deputy commissioners come chairperson of District Child Protection Committee. I would like to inform you that in order to take forward the matter related to recruitment process of contractual staff of DCPU and government run CCIs under Mission Bachelo, the government has constituted the district level committee. In this regard, it is informed that the advertisement for filling of the various positions will be issued centrally by SCPS Assam. The process of recruitment may be initiated only after issue of advertisement by SCPS Assam. So this committee was supposed to conduct the recruitment process. Instead of that, Lordship, the committee constituted by the Director of Women and Child Development Department has conducted the recruitment process, Lordship. And
Yes,
if you
Mr. Nath.
But the committee's jurisdiction of the authority has been challenged in the new writ petition, blood. It has been listed today. It has listed today, blood. But the selection process has been conducted and by the director with the approval of the government. And this is the approval of the government. I have received this, blood. I'll respond to this. I'm just for today's purpose, blood. I'm indicating the approval of the government, and the government has directed the member secretary that conduct the recruitment process. The government has approved that it should be conducted by the Director of Women and Child Welfare.
But this has to be said because it was earlier it was a good.
Earlier
we
in
covered this.
2022, what my learned friend has indicated, that was a process adopted in 2022. Now, Malad, this is the approval of the government. Malad, I'll respond, Malad. Whatever the fresh challenge has been brought in this petition, Malad, I'll respond to that also. This is I'm just indicating the approval of the government, that government has approved that the process should be conducted by the Director of Women and Child Welfare. That Director of Women and Child Welfare has not conducted without the approval of the government. The government has approved it. I'm just indicating that.
Made out of this because this notification has to be superseded.
Yes, Malad, with the approval of the, yes.
No, approval doesn't mean superseding.
Malad,
A notification of the governor has to be superseded.
Malad, pardon, Malad, I just, Lordship is indicating which notification, Malad.
Page 151 of the earlier petition, the notification of the governor will be binding. It doesn't say this is for the present year.
Lordship. Well, but it was issued by the Principal Secretary, Malad, page 152.
It's okay, but
Yes.
once
This-
they refer to the name of the governor, then once.
Yes,
it
yes,
is something
yes,
else.
yes. But it was in October 2022, it was issued, but this time around, with the approval of the government, they have indicated this. No, I'll respond to that. I'll respond to that. I'm just indicating the approval of the government. Government has done that.
But Mr. A.D. Chaudhary doesn't count for the petitioner. The constitution of the recruitment committee.
Like, Here, just Malak, if Lordship kindly allows me. Here, Malak, they appeared in the process, they failed to succeed, that thereafter, Malak, they have by one, they are bringing the challenge.
It's okay.
Lordship.
We note that. The formation of the district level selection committee by the principal secretary to the government of Assam, Department of Women and Child Development. Right. Notification. By order dated 19/9/2023. This 19/9/2023, where is the challenge? 19/9 this order of 19/9/2023. In your petition, there is no challenge for it.
It's a new petition which has come as item.
Which prayer? Page 42 is the constitution of the committee. Is it not?
This constitution of committee is place number 99.
No, in this new writ petition,
Yes, Lordship.
page 42 is the order of the selection committee being constituted, right? Mr. Nas,
Yes,
this is not in the challenge.
No.
It is challenged at new writ petition at page number 29, Lordship.
29. Which pair? Tell us the pair number.
Page number two, prayer number 2, Lordship. Set aside and cause the selection committee constituted by the Director of Women and Child Development Assam to select construction staff in district child production unit, especially for the post of district child production officer.
So which is that order? Here, prayer number 2 is a letter dated 24/8/2023. Now, where is that?
24, it is Lordship, annexure A, Lordship, page number 98, Lordship.
In the writ petition, page number?
41. Nothing like this. This is 41, Lordship.
So this is not the constitution of committee, this is a direction.
Direction, Lordship.
This can't be quashed.
No, Lordship, I have prayed to pass that committee, Lordship.
Where's the prayer? Tell us the prayer.
It is prayer number 2, Lordship.
Read the prayer.
Set aside and pass the selection committee constituted by the Director.
You can't do that. You see, this constitution is page 42. Page 42 order is not under challenge.
42 is also under silence also.
Please show us the prayer. I am this for the 10th time asking you.
Prayer number 1, Lordship.
Read it.
Declaring that the pursuant to formation of the district level selection committee by the principal secretary to the government of
Mr.
Assam.
Chaudhary, I don't have a time. You read this page 42, the order is 19 September 2023.
Yes, Lordship.
Please tell me where is the challenge?
This is at prayer number 2, Lordship,
Please.
of the new petition, Lordship.
You ask anyone, there's in the back, there's so many friend lawyers of yours. Ask them to read it. If they say anything, I'll pass an order, otherwise I will dismiss it. I appoint an arbitrator. Any lawyer, you just move around, look at any of the lawyer and then name him to be your arbitrator. You dismiss your writ petition. You tell us you have so many friends with you behind. There are 30 people.
Also, kindly take up this matter after some time, Lordship.
After some time, I have already read it. We are dismissing a writ petition. You can't entertain a challenge which is not the prayer. The constitution of the committee made by that. To conduct selection of contractual staff in various positions of district child protection unit has been assailed by filing this writ petition under Article 226 of the Constitution of India. To stop. Although the next, although the name say the committee has been constituted with 9 officials whose by designation, whose and their designation appears in the notification dated 13/10/2022. Oh, sorry, by the order dated 19/9/2023. 7 officers, not 9. On the ground that it is in contravention of the government notification dated 13/10/2022. So, next, how, as per the previous made in this writ petition, the said order number page 42 like order number so and so dated 19/9/2023, by which the committee was selection committee was constituted, is not under challenge. However, the challenge is specifically made to a letter number, page 41. Dated 24/8/2023. This is not clear. You see it from page 29. Page 29. Here. Letter number. Issued by the member secretary, comma, SCPS from Assam. The full name, State Child Protection Society, Assam. In the absence of the challenge to the notification, dated, order dated 19/9/2023, by which the committee was constituted, comma. The court finds that the challenge will not be maintainable. First off, in view of the inherent defect in the petition, comma, the petition stands returned to the petitioner. To the petitioners, to liberty to approach again in an appropriate manner. In item 56. What do? We adjourn the matter?
Lot.
56, we adjourn it? That's.
Maybe taken on Friday. There is some urgency. There is some urgency on our part.
Okay, today we won't have time because there's a long list.
Lot. On
Friday,
Friday. Lot.
both sides are represented. Does this matter on? Friday.
Lot.
There is an interim order operating in item
Yes.
number
I don't know, interim order passed by this, let's extend it till the next date of listing.
Lot. Malat, I'll take back the instruction.
Instructions.
Lot.
Instructions.
Always. Yes.
Item 15.
Lordship, the present petition as such, it relates to opening of seal cover. Under a DPC. If I may take your lordship to the facts of this case, your lordship.
No, not about it, we can only notice right now. We can't do
Only
anything
on a
about
small
it.
point,
Yes.
because the law as such is very much settled by the.
No, not in motion, without giving them an opportunity
Yes,
of
yes.
responding.
Is that there is some kind of urgency because the petitioner is going to retire soon, that's why.
Okay. When is your retirement due?
Within 1 year, within the coming next one.
Heard Mr. D. Border and then counsel for the petitioner. He will be issue raised in this writ petition. Issue notice returnable on, give a date after 5 weeks. So and so. Mr. S.K. Midhi, Leonard, CEC accepts notice on behalf of respondent number
1 to 4.
1 to 4. And Mr. Dr. A to B, then counsel accepts notice on behalf of respondent number 5. Therefore, issuance of formal notice is dispensed with. However, extra copies of the notification is served on them in the course of the day. We'll give it today or tomorrow?
Tomorrow holiday,
Yes.
8 on it.
Within 2 days. Next, the respondents are put to notice that the petitioner claims that he would be superannuating in about a year's time,
2005. So 2025, I'm sorry.
2025. Next, this one,
19th June.
Highly obliged.
Item 18.
My lord,
Just a moment. Where is the speaking order?
my lord,
10-4.
speaking order is at page 143. My lord, I can see a problem in this writ petition now, my lord, in the prayer part. Unfortunately, my lord, this speaking order has not been prayed to be set aside.
Okay. On the prayer made by Mr. Khan, the counsel for the petitioner, is permitted to make necessary correction in the prayer of the writ petition by hand, which shall be done in the presence of by providing freshly typed copy of the prayer to be incorporated in the writ petition by permitting substitution of the substitution prayer of pages 14 and 15 of the writ petition. First of the type copy of page number 14 and 15 shall be provided to the AOJ within AOJ, civil rule pending section. Shall insert the amended pages as page number 14A and 15A respectively. So the existing pages 14 and 15 shall be kept on record after striking it out. So the matter will be listed in the motion column after these corrections are made. Mr. D. Gogoi and Technical Counsel for the Health Department is present. The old pages will remain. It will strike out and will remain.
I am grateful, man. I'm so grateful. Grateful, man.
Item 19.
Please, your lordship. My lord, the matter pertains to compassionate appointment, my lord. The respondent number 6, my lord, whose name appeared below the petitioner, my lord. She has been recommended for appointment on compassionate ground. Yeah, if your lordship comes
Guide
to
of
page.
33 2016,
Yes, my lord.
but now your reputation will not be maintainable.
My lord, in fact, in the year 2018, her case has been considered, my lord, that minutes your lordship will find at page 5, my lord, wherein it was observed that, my lord, page annexure 5, page 23, my lord. In the year 2018, her case was considered, my lord. And a relevant portion at page 24, my lord. And the person below the petitioner has been recommended for appointment in the year 2022, my lord.
You only get a lifeline till next date. I'm not discussing a writ petition, but
No, my lord,
Yeah.
if your lordship
Yeah.
comes to page 32, my lord, the person.
in your order passed in item number 1, you can
Yes,
have
my
a look at that.
Yes, my lord.
I'm issuing a notice, but
My
lord,
this is the same case.
immediacy is lost, my lord.
My lord, kindly consider page 32 for a moment.
No, you consider the earlier order of the court. We are telling you item number 1.
Yes, my
You
lord.
consider that and then make your.
My lord, in that case, the respondent number 6, 6 should not have been appointed, my lord. She should not have been recommended, my lord. Because,
No, that's okay. We are issuing a notice, but we are telling you what is the fate.
yes, my lord.
Mr. D.P. Barat and counsel for the petitioner. And Mr. R. Dhawan and senior government advocate appearing for respondent numbers 1 to 5. claiming appointment on compassionate ground against husband of the petitioner who died in harness on 30/3/2016.
Died in a railway accident, my lord.
It's okay.
Yes, my lord. It is-
Yes. And setting the appointment of respondent number 6. On present, a petition has been filed under Article 226 of the Constitution of India.
Because
The
as per
Additional
number-
Senior Government Advocate has proposed the maintenance of the petition. Next, be that as it may, issue notice returnable on same day. Compassion is on. What dates we are giving? Compassion is on 10/6/2024. Receive extra copies of the reflection be served on the government advocate for respondent numbers 1 to 5. But the petitioner shall take steps within 2 days for service of notice on respondent number 6 by registered post PVD. List on Swinson.
10 June. Item 47.
Obliged, my lord.
That's all. Issue of maternity will be also heard on the next date. Yes.
Last
47.
on last occasion, instruction was sought for regarding status of appeal lawsuit pending against the petitioner.
Yes.
Lordship, the Revenue Department Council was supposed to get the instruction as to the status of the appeals.
SC revenue. SC revenue.
I may just call him because he was here
Okay.
after some time.
Item 50.
My lord, I am praying for an accommodation of 2 weeks, my lord.
Yes. Two weeks. Just-
Other matters were also before your lordship, and there they have been given the second medical report. But the reply which was given to me by the department, it contains only the first medical report, so I have to take necessary action, means instructions, one.
Okay. Mr. F. Khan, the counsel for the petitioner. Pays for adjournment to enable him to obtain instructions. Matter stands adjourned today, list after 2 weeks. 2 weeks.
Obliged,
Item 20 for admission.
Yes, Mr. Dhar.
My
Any
lord, I have,
dues?
I have received the instruction, my lord. I'm just placing it before lordship. Whatever dues, my lord, everything has been paid and that has been communicated to her, my lord.
You've been paid all your dues. Give a copy to him.
Yes, my lord. I have a single copy. I will just make a copy and give it to him, my lord. Or else, I can bring it on, if required, on affidavit also, my lord. Either way, my lord direct, I will do the same.
My lord may grant us 1 week time. My lord, main counsel isn't.
Okay. Make a photocopy and give it to him.
My lord.
Both sides are represented. Mr. R. Dhar, Learned Director, Senior Government Advocate, has produced a copy of instructions dated 4/2/2024. Where it is stated that the
Nine,
unpaid honorarium
nine, five,
of the
91010.
husband of the
937.
substituted petitioner has been paid and no dues are payable. So let a copy thereof be provided to the counsel for the petitioner, so as to enable him to obtain instructions. Actually, instructions produced are returned, or being produced on the next date of listing, just on the date after a week.
One.
21.
Item 21.
Can it better be taken up after some time also? Senior counsel is a Kenchur is on legs on his.
It was Judge. After some time.
Lordship.
22.
Lordship, matter relates to compassionate appointment in Canara Bank, Lordship. They have a scheme. So under that scheme, petitioner had paid for compassionate appointment. The deceased had died, leaving behind the petitioner, that is the son, and his old aged mother. She is now 74 years. That is the grandmother of the petitioner. And Lordship, Lordship will kindly be pleased to peruse the rejection order. They have considered and rejected my case. Page 41 is the rejection order. Rejection order. Last paragraph I am reading, Lordship. We are now informed by the head office that on perusal, processing of the request, representation and the connected papers submitted by the applicant, it is found that there were no mitigating factors, conditions to be considered which deserve immediate assistance for relief by providing compassionate appointment. As such, the request does not warrant for favorable consideration. So my humble submission is that, Lordship, this order is totally vague, non-transparent, Lordship, and they have not discussed my financial position. And there is a detailed procedure laid down under the scheme, Lordship, that under the scheme, the detailed procedure is at page 19, page 27, para 19. The procedure which has to be undertaken for consideration of compassionate appointment, para 2 I am reading, Lordship, page 27, para 19, subpara 2. An application for appointment on compassionate grounds shall be considered by the committee of officers consisting of 3 officials, 1 chairman and 2 members in the rank of Deputy General Manager, Assistant General Managers, that is Deputy General Manager HR Wing, and 1 executive each from Recovery Wing and General GA Wing. Assistant General Manager, Divisional Manager, HR Wing shall be convener. Now here in my case was not considered by a committee. It was rather considered by one Sri Sunil Kumar, Assistant General Manager. And thereafter, Lordship will see paragraph 4 of the procedure, page 28.
Just a moment. You are for the bank?
Yes, my lord. Regarding this scheme and the procedure, at first they must furnish genuine details in their application for compulsion employment. That is in page 33. Regarding their application, that they have mentioned that they claim for SC regarding age relaxation, but they could not provide the relevant documents to the bank. And father expired on 12th of October
In
2016.
compassionate appointment scheme, where do you find that the disclosure of caste is required for
Yes.
consideration, extension of relaxation of age? Where do you find in the compassionate appointment scheme?
Means they themselves have made application.
They may show so many things. Now you are taking a stand, you are making a submission before the court. Under your scheme, which is placed at page 20,
Yes, my lord.
where is the requirement that the overage should be condoned, the age must be properly stated? Where is that requirement?
And secondly, the PAN
No,
card.
not secondly, after if we don't proceed with the first, this repetition gets allowed on that ground alone.
Secondly, regarding the financial inquiry done by the bank.
So you admit that the relaxation of age is not a requirement under your NHO 5, right?
Right.
Okay, next.
And secondly, regarding the PAN card, means they have furnished details that and they have no income. But after the confidential inquiry by the bank, it has been seen that they have taken loan of rupees 20 lakhs in the year 2022. And for sanction of loan, there must be income tax return of previous 3 years. Means all this delay caused by them was
Unfortunately, what is the document you have annexed to your affidavit in opposition?
right now they are running a business since
Where is the
2007.
document? You have made an inquiry. Where is the document?
Yes, and that I shall furnish in the next date
No,
regarding
don't
this.
do it. Don't do it like that. We allow the writ petition, then you do it. When you go in appeal, you add those documents. You have started your argument by saying that it's not there. You have a document, you say, you see, ultimately, madam, you have said 5 or 10 rupees in photostat. 2 copies you'll have to give to court. So if it is that letter is 5 rupee, 5 pages, so 5 plus 5, 10, your own copy 15, his copy 20, so you have to save 20 rupees. Yeah, along this writ petition, this practice we won't allow. This practice we won't allow. You have saved many rupees, not only this. In your affidavit in opposition, you say that you have a Indian IBA, what you call, Indian Bank Association documents. That also you have not annexed. You have saved a lot of money for the bank. You should be happy. You should be happy. We allow this writ petition. When you are filing a reply, you should be very cautious. Because once we spend 5 minutes there, then you can't take us for a ride.
And Lordship, as per last day's order, Lordship, they were directed to furnish original proceedings of the committee, if there is any, or if by way of an affidavit. So on person to that, they have filed one affidavit also, which is at page 56, Lordship, on 6/4/27. But no proceedings, no report of the proceeding is enclosed to that, Lordship. Only an affidavit making some statements have been filed, but neither any original proceeding nor a photocopy of the proceeding has been enclosed, in spite of a direction of this honorable court by order dated 2/2/24. Regarding the loan thing, Lordship, I had also asked him once. He told that he took a loan of 20,000 rupees. Very poor people, Lordship, not 20 lakhs, 20,000 loan. Principal amount 20,000 only. These are vague submission without any record basis.
Okay, heard Mr. G. J. Sharma, learned counsel for the petitioner. And Miss
S. Chakraborty.
S. Chakraborty, learned counsel for the respondents. The case of the petitioners. But still you are hit by, Mr. Sharma, you are still hit by this judgment of the Supreme Court. Now we are considering the, in item 1. If there's a delay in entertaining whatever the reasons be. After this, the death was in 2016. We are now in 2024. After 8 years, we can't allow that.
Application made was well within time, Lordship. Period for making application is 5 years as per para 9.1, page 23. So he
Page.
page 23. Page 23. 9.1. I'm reading, Lordship. Time limit for considering applications. Application for employment under the scheme from eligible dependent will normally be considered up to 5 years from the date of death or retirement on medical ground, and decision to be taken on merit in each case. However, bank can consider request of compassionate appointment even when the death or retirement on medical grounds of the employee took place long back, even 5 years ago. Now, my application is dated 21/1/2019.
No,
Actually, prior to that also he submitted application, but that was not in proper format and he did not keep a record of it. But proper format application is 21/1/2019, page 31.
Okay. The
within
father of the petitioner died in harness on 12/10/2016 while working as peon in Canara Bank, Sikh Temple branch. So at the time of death, he left behind the petitioner a married daughter and his mother. The application for appointment on compassionate ground was made by the petitioner on 21/1/2019. But his case has been rejected by the impugned communication dated 16/12/2022 on the ground that there were no mitigating factors of the conditions to be considered which deserved immediate assistance for relief by providing compassionate appointment. The said order of the said communication is under challenge in the present writ petition filed under Article 226 of the Constitution of India. The opposing this writ petition, the Learned Counsel for the respondents has submitted that the petitioner has not come with clean hands and she has, and the petitioner has not disclosed the documents of his caste. Which was submitted later. And therefore, on an earlier occasion, the application of the petitioner could not be considered due to lack of document. It is also projected that at the time of submission of application, or the petitioner was 27 years of age, whereas the limitation of age requirement was 26 years prescribed for eligibility of sub-staff recruitment under the general category. Accordingly, it is submitted that the petitioner had suppressed material facts and did not come with clean hands. Next one. It is also submitted that she has received verbal communication from the respondents that the petitioner has applied for a loan of rupees 20 lakhs. And therefore, in order to obtain such loan, the petitioner had submitted income tax records.
That is already obtained loan in the year 2022, my lord.
Okay, the records, which includes what you call income tax returns, and that the loan was sanctioned and released on
That is on 26th of August 2022,
26 August 2022.
as per the civil report.
She is also informed that the petitioner has a good net worth as reflected in his civil SCI-BIL report.
And still now they have obtained 5 loans, my lord.
It is submitted that the petitioner has submitted, has obtained 5 a loan under 5 different accounts of the heads. Next, brother. It is noted that the petitioner is relying on the scheme of compassionate appointment of Canara Bank, by circular number 143 of 2015, dated 23/2015. Full stop. In their affidavit in opposition, comma, the respondents have not disowned the said document, which is annexed to the writ petition, is annexure 5. Full stop. Will not denying that the said circular number 143 of 2015 is in force. Stand has been taken in the affidavit in opposition to the effect that in paragraph 5 of the affidavit in opposition, that the scheme for compassionate appointment as prevalent at the time of death of the employee was framed as per the IVA guidelines. Unfortunately, the said guidance is not on record, and the respondents have also not denied the scheme for compassionate appointment by circular number 143 of 2015, dated 20/3/2015. So therefore, for all intents and purposes, as the existence of the said circular number 143 of 2015 has not been denied, the same shall prevail for the issue raised by the petitioner in this writ petition. Full stop. Next one, the learned counsel for the respondents has not been able to point out from the said circular number 143 of 2015 that there is an age limit prescribed for appointment on compassionate ground. Full stop. Therefore, notwithstanding whatever the age, whether the age of the petitioner is about 30 years on the at the time of filing of this writ petition, in the absence of any cap up to which appointment, after which the cap of age, after which the appointment on compassionate ground cannot be made, the stand taken by the respondent regarding the age of the petitioner does not hold good. Next paragraph. Insofar as the issue raised by the petitioner, respondent, is that the petitioner had applied for as many as applied and got as many as 5 loans, and one of the loan granted to the petitioner is to the extent of rupees 20 lakh. The court finds that the respondents are silent regarding that aspect of the matter in their affidavit in opposition. Therefore, any submissions made in course of adjudication of a writ petition, which is not supported by a stand taken in the affidavit in opposition, cannot be taken into account. Next paragraph. On the point of delay in making this application for appointment on compassionate ground, with this writ petition for appointment on compassionate ground, the learned counsel for the petitioner has successfully demonstrated that as per clause 19 within bracket 2 of the circular number 143 of 2015. No, where is that?
9.1, page 23.
9.1 of the circular number 143 of 2015, it is provided that the application for employment under the scheme from eligible dependents will normally be considered up to 5 years from the date of death or retirement on medical grounds, and the decision the decision is required to be taken on merit in each case. Full stop. The counsel for the petition has also demonstrated from clause number 19 within bracket 2 of the said circular number 143 of 2015 that an application for appointment on compassionate ground is required to be considered by a committee of officers consisting of, you copy this, put it on the flag, pink flag, page 27. 2. Full stop. Now, from the contents of the where is your impugned letter?
41, page 41.
A copy of the impugned letter dated 16/12/2022. Comma. It is not clear as as to whether the committee as envisaged in clause 19.2 of circular number 143 of 2015 had considered the claim of the petitioner for compassionate appointment. Full stop. In the contents of the said impugned letter dated 16/12/2022 is quoted below, page 41. Next paragraph. As the said impugned order does not reflect the specific reasons, except a vague statement that there are no mitigating factors and conditions to be considered. This court by order dated 9/2/2024 directed the respondent authorities to produce the proceeding of the committee constituted under the policy for consideration of the case of the petitioner on compassionate appointment. Full stop. Although the respondent numbers 1 to 5 have filed their affidavit on 5/4/2024, the order of this court has not been complied with, and the proceedings of the committee has not been produced. The only stand taken in the said affidavit filed on 6/4/2024 is that the dependents have been paid terminal benefit to the extent of rupees 6.72 lakh. And as the father of the petitioner expired in the 2016, and the family has been able to manage all these 6 years. It should normally be taken as an adequate proof that the family had some dependable means of sustenance. For this stand is taken that the daughter of the daughter of the deceased employee is married and staying separately with her family. Next paragraph. In this regard, when the scheme of compassionate appointment of the respondents mandate that the application can be considered up to, for compassionate appointment can be considered up to 5 years. And it is not in dispute that the petitioner did apply within that said time. And the rejection of the candidature of the petitioner by the impugned communication does not disclose the parameters on which the case of the petitioner was rejected. And nothing is brought on record to show that the committee which considered the application of the petitioner was duly constituted. The said communication cannot stand the judicial scrutiny of the court, and therefore court has no hesitation to set aside and quash the letter under reference number, letter of the Assistant General Manager of Canara Bank, the reference number GCO semicolon from CUMP. Next word is appoint APOINT colon 67671 colon 3239 colon 2022 dated 16/12/2022. This is page 41. The matter is now remanded to the Canara Bank, Sikh Temple branch to reconsider the claim of the petitioner for appointment in compassionate ground, strictly in terms of the scheme of compassionate appointment by circular number 143 of 2015, dated 23/2015. As the next paragraph, as the application of the petitioner is within the time prescribed by said circular number 143 of 2015. I will give the clause number 91 of the council. The application of the petitioner shall not be rejected on the ground of delay in consideration. Failed decision by the respondent shall be taken within outer period of 3 months from the date of receipt of a certified copy of this order. It is needless to say that the whatever order is passed will be duly communicated to the petitioner. And we again express our thanks for saving money for the bank. Don't annex relevant annexures. A lot of money is saved. Right. Thank you for that.
Time being item 47.
Yes.
Appeal number 61 is pending before the Director of Land Records. And other 3, my lord, that petition was under appeal.
No, first of all, you see, this is something to be considered by whom? Who is the appellate authority?
DLR.
DLR is nominated.
Lordship.
So then why is not passing orders?
Lordship, my lord, that what happened when the appeal was filed before the concerned, my lord, that Lower Assam Division, Lordships. When the Lower Assam Division has been, my lord, abolished, then, my lord, it goes to the, my lord, the GAD. The GAD was not able to, my lord, take up this matter. Then again, the matter was pending. And all the matters were, my lord, sent to the, my lord, their concerned deputy commissioner. After the, my lord, the news, my lord, the directorate appellate authority has been formed. Now they are, my lord, forming the February or, my lord, I forget the, my lord, month. first February. So first February, it has been, my lord, appointed as a DLR, my lord, as the appellate authority. That's why, my lord, it was pending. Lord.
So another uncomfortable question. I hope he knows how to adjudicate.
Lordship, my lord, that only.
No, not
because-
that. He's hearing an appeal. I think he knows how to adjudicate.
Lordship.
Okay. So we list it after a month. In the meantime, you tell us whether this appeal has been taken up or not.
Lordship, my lord, only, my lord, that I have received the debt instruction, only one appeal has been received by the, my lord, appellate authority, my lord, before the, my lord, appellate authority on, my lord, that director of land records. And other appeal, my lord, whether it is before the concerned deputy commissioner or, my lord, the office of the, my lord, Lower Assam division, my lord, where they have been filed, my lord, it is not mentioned before in the, my lord, petition also.
Lordship, page 39, Lordship.
Just a moment, just a moment.
So, site counting.
So what is the purpose of coming to court? Why the petitioner is so eager to come to court?
Against the selection of petition number 2, 3, and 4, Lordship, the appellants earlier approached before this honorable court, Lordship, and this honorable court filed separate.
No, that's okay, but what is your interest in having coming to court?
Lordship, for last 1 year, Lordship, the appeals are pending, Lordship. For last 1 year, the.
How are you aggrieved? Your discharging function as
No,
the
Lordship,
no,
no, Lordship.
but who has
On
said
last
it?
occasion, Lordship, that this honorable court directed to consider dispose the appeal within 60 days,
No,
Lordship.
but there is no stay operating.
No.
But we are not appointed, Lordship. Due to this appeals only.
Where is your statement in your application that you have not been appointed?
Lordship, paragraph 14, Lordship, page 15. Lordship.
Paragraph 14.
Yes, Lordship, page 15.
But if you are not appointed, you can't be discharging your duties. Most of the selected candidates, but due to pendency not being appointed.
Lordship, there, if your lordship goes to page number 36,
56.
on the petitioners, paragraph number 8. It is submitted that till now no appointment has been made by the respondents in the post of Gav Pradhan, appointing respondent number 7 as the Gav Pradhan of lot number Borgoli Part 1, village and Boria, Musa, Kolyapur Revenue Service, district of Nagaon. If that be true, the respondent authorities will not pass any order appointing respondent number 7, if not already issued, till the appeal filed by the petitioner is disposed of.
Oh, that is why he's here.
Yes, sir.
Now, this appellate authority, the Director of Land Records,
Lordship.
if there is no writ petition, no appeal pending,
My lord, what happened, the appeal is pending, earlier, my lord, they have filed the appeal before the, my lord, that GAD.
I understand. But now what to do?
My lord, it was sent, my lord, they have to, my lord, ask the concerned deputy commissioner to, my lord, those who are.
So
the
why the
applications-
appellate court will ask, you see, somebody will tell us that the court of so and so has transferred a matter to this court. Let us say, assuming that this
Lordship.
happens, it will not happen, but still it happens. Now, will we inquire with the other courts that whether you have sent or not, whether you have done it or not? I can't do it.
Lordship cannot.
Then if the appeals
My,
are not
the
there,
duty of the, my lord, that the appellate authority, my lord, whether any appeal is filed, my lord, they ask to the concerned deputy commissioner, my lord, that.
so we appoint a SIT to find out your records. Suggest the names,
Your lordship, if I may take your lordship to page number 39.
39, yes.
Therein after this whole confusion was there in this whole process, the GAD department wrote to the district commissioner in Nagaon, asking them to now transmit the appellate files to the revenue department. This is dated December 2023.
I understand, but the files, if they are not sending,
They are not.
you suggest the names, DGP, additional IGP, who will be the members of the SIT?
Lordship, kindly grant me some time. I'll get an instruction as to whether this file has been sent on to. Then that will actually put things in the proper perspective, your lordship. Because maybe they have signed, because this is of December 23. And of course, election is going on because
No,
of that.
we'll permit, you see, we can pass orders couched in a very rosy and lucid language. Everybody will be, even in this, even tomorrow, they'll comply with the order. We'll just have to write, we constitute a SIT of DGP, IGP, additional IGP, the district commissioner of police. And to track the record, if they can't track, these officers who are in custody of the records would be arrested. How much time? Till
Lordship.
Monday, we give you time,
Next Wednesday, your lordship.
next
because
Wednesday. Okay.
Tomorrow there is election. So at least after that, your lordship.
The how do you say, Alam, counsel for the petitioner,
Yes,
Huh?
yes, Alam.
S. Alam, then counsel for the petitioners. Mr. J. Hendrick, learned standing counsel, learned government advocate appearing for the, you are for revenue,
Revenue, lord.
standing counsel for the revenue department. And Mr. D. Boral, and government advocate appearing for
4, 5, and 6.
respondent numbers 4, 5, and 6. Next, para. The petitioners were appointed as government Gambura. And their appointments have been challenged by the aggrieved persons by filing statutory appeal under section 162, capital C
See, lord.
of the
Executive instruction.
executive instructions under the Assam Land and Revenue Regulation, 1886. Next one, the case of the petitioners is that pending adjudication of the appeals. This could be order dated 29/3/2023. And directed that the respondent authorities will not pass any order appointing the petitioners till the disposal of the appeal. Next, for the grievance of the petitioners is that their appeal, the appeals filed against them have not been adjudicated. Next, pursuant to the previous orders of this court, the learned standing counsel for the finance department. Oh, no, this is by you, by the revenue department, has produced a copy of communication dated 3/5/2024 by the additional director of land records, Assam, informing their learned standing counsel that the appeal filed by one Pranjal Das against the selection of the petitioner number 1, appeal number 61 is pending for disposal before the Director of Land Records and Surveys, etc. And that in respect of other 3 petitioners, namely Krishna Karki, Jyotish Bora, and Nazrul Islam, no appeal is pending before the said authority. Next one. Yes. Now, who has got those records of erstwhile commissioners? Who are the custodian of records?
DC Nagaon.
DC Nagaon.
These were returned by the JD.
DC Nagaon. Page 39.
Page 39.
Next one.
2012-23.
Next one. In a writ petition file against the petitioner number 2 by Momin Bora, MOMIN Bora BORAH, which was registered as WPC 1618 of 2023. This court by order dated 22/3/2023 allowed the writ petitioner to file an appeal within a week. And the writ petition was disposed of. Similar order was passed on 17/3/2023 in writ petition filed by Ajit Ghorsane, GHORSANE, being WPC 1519 of 2023, challenging the appointment of the petitioner number 3. A similar order has been passed. Around 7 days time to file an appeal. Full stop. Next, challenging the appointment of the petitioner number 4, Nazrul Islam, one Abdul Hanan, Hannan, at 5 WPC 1763 of 2023. Wherein the order dated 29/3/2023, an order was passed that similar order was passed to permit the petitioner therein to file an appeal within a week. And in the said petition, it was directed that the respondent authorities would not pass any order appointing the petitioner number 4 herein till the appeal file is disposed of. Next one. The learned government advocate has submitted that the records of the erstwhile Commissioner, Lower Assam Division,
Central Assam Division.
huh?
Central Assam.
Central Assam Division are all placed under the custody of the District Commissioner Nagaon. Therefore, the District Commissioner Nagaon the bracket respondent number 4 shall provide instructions to the learned government advocate as to whether the appointment of the petitioner numbers 2, 3, and 4, namely so and so, are available in the records of the appeal records of the Commissioner, Central Assam Division. The name of the prospective prospective applicants are also indicated against the 3 writ petition numbers referred above. Next paragraph. On the in view of the ensuing elections, the learned government advocate is granted 10 days time to obtain instructions by sending a downloaded copy of this order to the District Commissioner Nagaon. This one, give a date after 10 days.
Extra copy of the writ petition may be coming.
Oh, notice is not issued in this
Not,
case.
not.
Issue notice returnable in
15/5.
15/5/2024. Requisite extra copies of the writ petition will be served on the runner state and department council in course of the day. Next, list on so and so.
Time being item 21.
This was too bulky to digest.
Well, there is some amount
Just,
of,
just tell me,
well, what had happened in this case.
because of the lot of readings I could not.
Yes, yes.
grasp.
Well, let me give a brief idea. Now, petitioner is presently working as a secretary to the government of Assam. He is at the highest slab of the civil service officer. Now, for 2019, my lord, his case was considered by UPSC, but he was found to be unfit because out of the 5 ACRs, in one of the ACR, there was an adverse remark for the year 17-18. Now, my lord, there is a set of procedures laid down by the government of Assam, apart from the 1992 rules. It lays down, my lord, how the officer has to initiate his own report, then how the reporting officer will do the reporting, how reviewing officer review it, and how accepting officer is to, accept it. Now there is a timeline, my. Now the timeline was, my lord, never followed. So as a result, my lord, I not only missed the chance in 2019, but I also missed the chance in 2020. Of course, by virtue of an interim order, my lord, one post has been kept vacant. But my retirement, at this next June, my lord, he is retiring.
Okay.
So, my lord, if at least if it is considered before that, in that case, his case can be reviewed, DPC can be held, and my lord, it can be considered. My lord, my lord, actually what had happened, this respondent number 7, my lord, there was a, my lord, I was at that point of time, I was a chief executive officer of a, my lord, Jila Parishad. Now, there was a litigation in the High Court. Coincidentally, I appeared for the petitioner in that case. There was a direction for disposal of a representation. I, as an CEO, my lord, I did my part, forwarded the file to the state government, but the then secretary, the respondent number 7, he did not do it. So there was an order for his personal appearance. So that enraged. Now I'll show, my lord, when I open up my case, how blatantly, my lord, he has prejudiced or, my lord, caused prejudice to the petitioner. And, my lord, there is one thing, my lord.
This adverse remarks against you, you are trying to rely on the Supreme Court judgment, which says even good has to be communicated.
Exactly, my. That Devdutt's case.
Huh.
Justice
So you are saying that so you are saying that this good
yes,
is an adverse against
even and very good also could be an adverse in an appropriate case. And,
But
my
you'll have
lord,
to-
the
but you'll have
timeline
to-
was not kept. As a result, there's, my lord, one more thing.
But you'll have to, if I
It'll
have to
take
take up the
some
matter,
time.
no, you.
I'll make a short
see
note.
This,
I'll do that.
list of dates, otherwise
Yes,
there
please.
are 13 affidavits to consider.
No, absolutely, my lord. In fact, we'll do that,
We'll take it up next Tuesday.
my lord. My lord, can I make one submission? Tuesday and Thursday I have checked up. Can your lordships keep it on this Wednesday or Friday? What I will do, I cannot complete in one thing. They will also do. At least if I get half an hour, 40 minutes time, at least I can, my lord, rush through. And I'll come up with the list of dates.
Now, there is another issue. After taking up various bench, service law, I'll have to be acquainted. There's a tendency to forget.
If your lordships can
therefore-
keep it towards the end also, say at 3:15 also, my lord, I'll get that time, I'll rush.
But those are miscellaneous days where motions and admissions are huge. And everybody wants a disposal at motion
Actually,
stage.
9, my lord, there is a full bench. Otherwise, I would have agreed. In fact, lordship is there.
Huh.
That matter.
Lordship has suggested 14th, no? Tuesday. Tomorrow is
Because
the
there I
holiday.
can, motion and admission, I don't have to, what you call, you see, those can be overlooked.
Tomorrow is the holiday. Next Tuesday is 14th.
16th of November.
You just agree to a date, see your calendar, there's a.
Yes,
Look, check your calendar.
Lordships can keep it on, my lord, Thursday, my lord. That is 16th.
16.
Yes.
Mr. Nath? But if I'm still continuing with the bench, you have to give me a short.
So, no, in any case, my lord, whosoever is the bench, I'll come up with a list of dates. That is for everybody's convenience, my lord. Yes. My lord, there is one very pertinent point in this case. As per the UPSC's own devised procedure, my lord, if the ACR is not communicated, then they do not take note of that. That prejudice also caused to me, my lord. That's the most serious part.
But see the appellate order doesn't say all these things.
Yes, my lord. If your lordship would kindly permit me to place one note of the personnel department.
No, the impugn order, which is that appellate order.
No, my
Mr.
lord.
Salim.
No, appellate order, my lord, they have, please come to my lord, page number, not one, appellate order, is the order to, personnel department reviews to. Just 1 minute, my lord. Yes. Personnel department or not. Please come to page 101, my lord.
Here you are relying on 102 where it says that.
Yes,
it
102.
was telephonic communication, not written.
And I can show the rule, my lord. Specific instances has to be made out. I'll just read out the
It's
rule.
okay, it's okay.
Huh.
Since I'm not continuing with any answers. But after
My
that,
lord, it's a blatant case. I'll satisfy your lordship.
because after this, I could not keep a track.
Yes. Telephonic, some cases, this will not do. The rule says unless you come up with specific instances or else invariably you must give good ACM. Otherwise, my lord, it will everything will be subjective really. It needs to be objective. In 2000.
Just give me the dates. What has happened when? Your regularization order is
My lord, that is in page number 99. We have,
just give me the date.
date is, my lord,
22/7/2005.
September 2005.
Annexure K2 repetition.
Page.
1 minute. Page 53, man.
52.
53.
53. Okay. Now, your promotion order came when?
Uh, 22/12/96, man. 95, my lord.
Pardon me?
Annexure D, page 32.
Give the date, please.
27/12/1995.
27/12/95.
95.
That cannot happen. Your regularization order you are saying is 2005.
Before regulation, he was promoted, man.
Oh, that can't be done. You're not
Respondent
even in
has
service,
done
you can't be
already.
promoted. You're not even in service.
Annexure D, my lord.
No. Once you are not in service, you are not, what do you call, you're not in the cadre. You can't be promoted. Your regularization order,
Regular as a handyman, my lord. Regular as a handyman, my lord.
as a handyman,
After reversion, he was regularized.
you challenge your order of, what do you call it?
Reversion, my lord.
No. This order of your regularization, have you challenged it?
Yes, man.
You challenge your order of regularization. Very good. Where is that? Which prayer?
Page 21. Prayer portion.
Page 21,
20.
20.
Prayer number 1. To promote the petitioner to the post of ruler.
No. Your order of regularization is 22/7/2005, right?
Right. Yes, man.
Your regularization was in the post of
Rural handyman, man.
roller handyman.
Earlier, he was working as a driver, but he is
So
on.
therefore, your appointment as roller has to be assailed. You will have to satisfy that first. Then only we can send it back for reconsideration.
He was wrongly regularized,
No,
man.
that's okay. But this order cannot stand. If this order is correct, then your promotion goes. So therefore, we have to protect your promotion, you'll have to set aside the order of regularization.
I may be allowed time to get instruction madam, from the petition madam.
No, not required. When you are hearing it, it's not required. You can take a decision. You are the conducting counsel. On issue of law, you can't take his instruction. It's a question of law, whether you want to save your regularization order or you want to save your promotion. So your petition fails on that ground alone. You're not in, you are not born in cadre, you can't be promoted. Yes, what is the citation?
My lord, it's Retable 124 of 2015, reported in 2017 3 GLT 376.
2000.
Oh, my lord, GLR, my lord, 2017 3 GLR 376.
376.
My lord. My lord, here the ratio laid down is, my lord, that once a person is, my lord, regularized in a personal post, he cannot be, my lord,
No,
here.
he is seeking regularization in the post of a promoted post. Question of, he is not asking for promotion after regularization.
He was reverted without any inquiry, my lord. Without inquiry, without any show cause, without notice, my lord.
So, my lord, first that regularization has to be set aside, my lord, because he has been regular in 2005. He has been sitting on it since
No,
then.
no, you see, that was something which I asked, but because of his inability to what you call, his inability to understand the gravity of the question, he can't put the petitioner to difficulty. So that petitioner should not suffer.
My lord, what is the promotion he is assailing about? We have stated in our affidavit, my lord.
What have you said?
My lord, it was a temporary, my lord, arrangements when detected, my lord, for 60 days. He was reverted back, my lord.
Where is that?
My lord, in our affidavit, page 72, running page, my lord. Para 4, my lord.
No, no, document have you annexed?
My lord, yes, sir. I'm coming there, my lord. All the letters A, B, C, D, E, F, G.
You have seen what we did when some money was saved for photocopy. You were there in court.
My lord, my lord, my lord. My lord will come to page number, my lord, 78. From here it starts our all annexed documents, my lord.
78.
My lord, running page, my lord.
But Mr. D.J. Burman, learned counsel for the petitioner, as well as Mr. R. Dhar, learned additional senior government advocate, appearing for all the respondents. Next paragraph.
My lord will
The petitioner was serving as a work charge roller handyman. It is posited that the said appointment was made on 4/12/1989 after undergoing apprenticeship training. Full stop. In course of employment, by an order dated 2/1/1990 issued by the then executive engineer, PWD within bracket RNB bracket close, mechanical division, Silchar. The petitioner claims that he was promoted to the post of roller handyman. In the first, he was appointed on 4/12/89 as a chowkidar. In the PWD mechanical workshop at Silchar. Thereafter this, he was promoted to the post of roller handyman. Full stop. It is projected that the service of the petitioner as work charged roller driver was extended from time to time. Full stop. Thereafter, by an order, where is that regularization order? Page 53. Thereafter, by
My lord, in affidavit, it is page 99.
In the petition minus page 53, annexure K.
thereafter, by an order number 122 dated 14/11/1996, the petitioner was reverted back to his original post of handyman of roller machine. And another work charged employee was promoted to the post of work charged roller handyman on the same day. Full stop. Accordingly, by filing this repetition under Article 226 of the Constitution of India, the petitioner is seeking quashment of the order dated, order number 122 dated 14/11/1996, and to issue a direction upon the respondent authorities to promote the petitioner to the post of roller driver with effect from 14/11/1996, and to regularize his service with effect from 22/7/2005. And for granting him consequential financial benefits. Full stop. Next, the learned additional senior government advocate has opposed the prayer and made it the writ petition. And it is submitted that full stop. Next para. On a consideration of the materials available on record, now it is observed that it is not in dispute that the initial appointment of the petitioner was a temporary appointment to the post of Chowkidar by order dated 4/12/1989. Full stop. During his course of service, the petitioner was appointed as work charge roller handyman for 60 days by the office order number 6 dated 2/1/1990. And it was a condition contained in the said communication that his service will be terminated after expiry of 60 days. Full stop. Though the petitioner claims that his appointment as work charge roller handyman was extended from time to time, but none of those appointments are substantive in found to be.
He is promoted to rural handyman, thereafter he is promoted to rural driver, madam, by annexure D. Case number 32.
None of those orders give him the status of a regular employee. That's all. The petitioner further claims that by office order dated number 171 dated 27/12/1995, he was promoted to the post of work charge roller handyman. No, sorry, to the post of roller driver under work charge establishment for a period of 60 days. Full stop. However, his appointment to the said post of roller driver and subsequent extensions, if any granted, also do not confer upon him the status of a regular employee. Full stop. In the absence of the petitioner becoming a member of any cadre, question of accepting his promotion to a substantive post cannot arise. Full stop. The documents annexed to the writ petition indicate that by office order number 3 of 2005-2006, issued by the Executive Engineer PWD, Karimganj NEC Division, pursuant to directives of the appropriate government, the service of the petitioner was regularized
Case 54, man. Serial number
as the roller handyman. Full stop. It is noticed that by the said order, the petitioner was brought. The petitioner was otherwise a work charge employee was bought under the regular establishment with effect from 22/7/2005. The posts were made personal to the petitioner and other similarly situated persons. And it was also provided that the said post would abolish as soon as the concerned incumbents relinquish their posts in any manner. Therefore, the petitioner came into the cadre of roller handyman with effect from 22/7/2005 pursuant to the hearing before referred order number 3 of 2005-2006 dated 5/10/2005. Full stop. Next paragraph. Before any ad hoc appointment or promotions made to the petitioner was only as a work charge employee and do not confer upon him the status of promotion without entering into the respective cadre earmarked for the post of roller handyman and obligor roller driver. Next paragraph. The challenge to the impugn order where is the impugn order? And it's H, where is that?
The next are IMN. Page number 47.
The impugn order, impugn office order number 122 dated 14/11/1996, reverting back to the petitioner to the post of work charge roller handyman and ad hoc promotion to another person from work charge roller driver from roller handyman to roller driver has been assailed almost after 17 years. So by the time the status of the person who was promoted in case of the petitioner by order dated 122 dated 14/11/1996 is not known. Full stop. The person was promoted by the impugn order is not a respondent in this writ petition, and in the absence of challenge to the said appointment, this writ petition otherwise fails. Next slide. The writ petition would also fail for another issue. This is the fact that the petitioner, the service of the petitioner was regularized by office order number 6 dated 2/1/1990. Full stop. The petitioner has accepted the said regularization order not 6, what is that page?
Page 52.
53. Office order number 3 of 2005-2006 dated 5/10/2005, whereby his service was regularized as a roller handyman. Full stop. The petitioner has not challenged the said regularization order dated 5/10/2005. Full stop. Therefore, having accepted the substantive appointment to the post of roller handyman, comma, the claim of the petitioner for being appointed as a work charge roller driver would not be maintainable. Next paragraph. Moreover, comma, the third reason for not entertaining this petition is that this court, in the case of Dilip Talabdar and others, was the state of Assam and others, within bracket 2017, bracket close 3 GLR 376, equivalent to 2017 within bracket 2, bracket close GLT 135. Has held that a person who has accepted the regularization order, which itself stipulates that they are regularized in posts personal to them, cannot have an enforceable right to claim promotion by further holding that promotion in a department can be considered only from the eligible employees in the feeder cadre. Therefore, as the petitioner was not even a regular employee of the PWD when his purported order of promotion was issued on where is that order? Promotion, annexure D, page.
Page 32.
Order of promotion dated 27/12/1995. Not give any substantive right to the petitioner, which would run counter to the regularization order of 5/10/2015. 2005, 5/10/2005. Next, therefore, on all three grounds, the petition fails and the same is dismissed.
May I please? I may be allowed to challenge the regulation order.
Now you can't,
Liberty may be granted me.
now you can't, you dismiss that. You dismiss that. After 16 years, you can't do it. There's
Okay.
another judgment which will come against you. There's a judgment of this court, where it has been said that order of promotion or affecting any other employee should be challenged at the earliest. Belated challenge will not be entertainable. Okay, I'm sorry, there's lack of time. Any other, in any other case, there is an interim order to be extended. I'm sorry, I couldn't reach all the items. Any, Mr. Viswas? Any interim order to be extended?
There is no interim order in my case.
Okay. Okay. But I must tell the bar, there is one thing I appreciate about Mr. Viswas
Yes.
is that he is always present in the references. He gives honor to those who have departed or those who are superannuating. 3 or 4 of them, I always notice you're always there.
I'm thinking, if I won't appear, who will appear for me?
No, you see, we have touched a very, very good issue when so many members of the bar is here. I had given this suggestion to many a times to the bar. I am again repeating it before the young members. I am not directing this to Mr. Viswas, but to all the other young members. You see, the bar can collect the photographs of the departed members of the bar, have it scanned without any cost in the pen drive, and have it placed in the TV you have in the bar, so that we will all remember those people who are now not with us. There are many stalwarts who are there in the bar. Many of you may be their juniors, and the memory of the senior goes fading away.
Right.
So what Mr. Viswas has said, I think young members of the bar should take it up so that at least the photographs of those who have retired from practice or those who are no more there, their photographs can be kept in the bar as in the pen drive, which has no cost.
Yes. Good idea.
Pen drive maybe 700-800 rupees would go, but I don't think anybody would mind. Even I am ready to sponsor if the bar requires TV and the pen drive, so that at least memory of the old departed stalwarts on the bar can be remembered. Many of them, we loved and respected them when they were in the bar, but now we are gradually forgetting. They were seniors from whose chambers 2 or 3 judges were elevated. People have become advocate general, and now we won't even remember their names.
Yes, very.
Like for example, we know Mr. Viswas. We also know that here his senior was Mr. T.C. Khatri. But who was the original senior, we don't know. We have lost that track. So, because I've seen him with Mr. Khatri, so therefore I'm presuming that he was Mr.
Yes,
Khatri.
I have started, he has brought me here. But
Okay. So you see, these are fantastic memories, which I think the bar should keep. Just think over.
good suggestion, we'll try to.
I have given many times, but nobody listens now. I'm growing old.
I'll take up the matter with the bar
Now,
council.
since I'm growing old, nobody remembers.
No, you
to
are
pursue
young, my
this.
lord.
No, I'm old. You all know my age. So please try to see that these things come up. This is not only for this bar. It
Yes.
can be replicated in every bar in the
Yes, yes,
state.
district court also you can do.
Yes.
Item 26, direction are issued for filing of the affidavit within 1 week on 8th of March. So my humble prayer is it may be listed at date. Item 26.
Huh.
Direction was issued but given to file the affidavit within a week.
No, all this will be rolled over because you are not fixing a date in any matters where the interim orders are not extended, because otherwise we'll be in a mess. Let us see that your item is 23.
20.
Let us see the item is 23. I am not passing order in 22, but I am passing order in 23. That gives a resentment, there is a complaint in the There was a complaint made against me in before the registry. So this has happened, and therefore, now I'm not passing orders where there is no extension of stay. If there's an extension of stay, please tell us.
Right.
Otherwise, tomorrow, please make a mention.
Right. Okay.
I'm not passing an order. There is a reason for that. I've disclosed it to you. But many may not like it. Today you may say yes, but tomorrow you may go and complain that order was passed in item 23. In my case, 22, no order was passed.
Right. Okay.
There we don't have any answer. And that becomes a default of the court. I'm sorry.
Okay.